whether they are voluntary at that point. We believe the burden shifts to the state of Ohio on that issue. I would note that in the dispatch reports that are summarized for the Highland County Sheriff's Department, the dispatcher is advised by Mr. Beatty that he has outstanding warrants for the arrest of Mr. Gillespie, but in fact that wasn't true.
All right, first witness.
Patrolman Mark Hamilton.
You know, we request a separation, but I...
All right. Are there any other witnesses other than the state's representative?
No.
All right, well, the separation will be granted. Have you been sworn in? All right, just have a seat over there. Pull that microphone over in front of you, if you would, please. Yeah, it should slide to that. All right. Remain quiet.
Could you please state your name?
Mark Hamilton.
And are you currently employed?
I am.
Where at?
The Greenfield Police Department.
And were you so employed on June 7th of 2022?
I was.
And on that date, were Patrolman Beatty and yourself investigating a motor vehicle theft?
We were.
Do you recall the type of vehicle that was stolen?
A red Dodge Dakota.
And where had that vehicle been stolen from?
The Adena Greenfield Medical Center.
During your investigation, did you travel to the Adena Greenfield Medical Center?
Yes, I did.
And while you were there at the hospital, were you able to review the video security footage of that vehicle theft?
Yes, I did.
And what did you observe when you reviewed that security footage?
I observed a black PT Cruiser enter the parking lot of the Adena Greenfield ER parking lot. I saw it stop behind the Dodge Dakota. I saw him exit the PT Cruiser, approach the driver's side door of the truck, open the truck door and rummage around for a short time, then re-enter the PT Cruiser and exit the parking lot. A couple of minutes later, I saw a male approach on foot, enter the truck, sit there for a couple of minutes, and then exit the parking lot inside the truck.
And while you were viewing that footage, did you recognize the male that entered the parking lot on foot and then entered the truck and drove away?
Based upon recognizing the vehicle in question and also the distinctive limb, I believe the male to be Sean Gillespie.
And this vehicle in question, did you say what type of vehicle it was?
It was a black PT Cruiser.
And were you familiar with that vehicle?
I was.
How so?
I have had numerous dealings with the owner, Brandy Thompson. I immediately recognized the vehicle and remembered the license plate as well.
So were you familiar with Ms. Thompson from previous dealings?
Yes, I was.
And from your dealings with Ms. Thompson, were you aware of who she was known to date?
Yes, Sean Gillespie.
Were you familiar with Mr. Gillespie from previous encounters?
Multiple encounters.
Do you see Sean Gillespie in the courtroom today?
I do.
Could you please point to him? Let the record reflect the witness identified the defendant.
Sure.
So after you viewed the video footage from the hospital, who did you suspect was involved in this vehicle theft?
Sean Gillespie and possibly Brandy Thompson.
And were you aware of what address Brandy Thompson and the defendant were known to sometimes stay at?
Yes.
And what is that address?
12291 State Route 28 West.
And is that in Highland County?
That is.
Did you also know the defendant to stay at any other locations or residences?
Various other residences in Greenfield, 733 Blaine, 734 Carford Pike, among others.
Did Patrolman Beatty and yourself decide to travel to 12291 State Route 28 West in order to attempt to locate the defendant, Brandy Thompson, and possibly the stolen vehicle?
We did.
And is that location, is that address outside of your jurisdiction?
Yes, it is.
And due to that address being outside of your jurisdiction, did Patrolman Beatty contact the Highland County Sheriff's Office in order to obtain permission for the two of you to travel to that location?
Yes, he did.
And was permission granted?
Yes, it was.
Now, prior to traveling to that location, did you attempt to determine if the defendant had any active warrants?
We did, but dispatch was not able to provide that immediately.
Had you previously checked to see whether the defendant had any active warrants, not just when you asked dispatch on June 7th, but anytime prior to June 7th in that time frame, had you checked?
Yes, several weeks prior to that, we had been looking for him because he had an active warrant out of the Adams County Sheriff's Office.
So, and was that warrant out at Adams County, was that within pickup radius?
Yes, it was.
But when you arrived at the State Route 28 location on June 7th, at the time you arrived, you weren't sure whether that warrant was still active. Is that accurate?
We were not certain.
Okay. And did you find out later that evening whether or not that warrant was active?
Later that evening, when we arrived back at the police department, yes, we found it was no longer active.
Okay. So when you arrived at 12291 State Route 28, what did you observe when you first arrived?
I observed a black PT Cruiser, Brandy Thompson's vehicle, parked in the driveway. There was another vehicle parked in front of it. Observed a male standing next to the PT Cruiser.
And when you arrived, was there a driveway that you pulled in? Could you just kind of explain that?
There was a driveway. One of our cruisers was able to fit in the driveway. The other cruiser had to park partially on the roadway.
And you mentioned this male that was standing outside. Were you able to identify who that male was?
I did not immediately recognize him, but he was identified as Charles Doherty.
Okay. And did you detain Mr. Doherty?
I did.
And what was Patrolman Beatty doing at the point that you had detained Mr. Doherty?
He walked past and made contact with Jackie Doherty, Jackie Stonerock, further into the property.
Were you able to hear any of that conversation?
No, I was not.
After you saw Patrolman Beatty make contact with Jackie, what did Patrolman Beatty do next?
Patrolman Beatty continued on towards the camper.
And where were you at this point when Patrolman Beatty's approaching the camper? Where are you at?
I was still standing with Mr. Doherty.
Can you approximate how far away you were from the camper at that point?
Maybe 50 feet,
Okay.
30 feet, somewhere in between there.
So from where you were at in the driveway near the PT Cruiser, could you observe the entrance to the camper?
Yes.
And was there a closed door?
No.
Was there a sheet or a curtain covering the entrance?
No, there was not.
So was there any type of covering to the entrance of this camper that
No.
you could see from your location?
Not that I could see.
Did you see Patrolman Beatty enter the camper?
I did.
And were you able to see what happened once Patrolman Beatty was inside?
No, I was not.
Was the defendant, so after Patrolman Beatty enters the camper, was the defendant eventually handcuffed and removed from the camper?
Yes, he was.
By who?
Patrolman Beatty.
And then was the defendant placed in Patrolman Beatty's cruiser?
Yes, he was.
Did you handcuff Brandy Thompson and place her in your vehicle, your patrol vehicle?
Yes, I did.
Did you advise Ms. Thompson of her Miranda rights?
I did.
Did she make any statements to you?
She advised me that while she was meeting with her probation officer, Sean Gillespie had her vehicle. He had stolen the truck and parked it behind Catch 22 in Greenfield. And then when she got out of her meeting with her probation officer, she had driven him back to 12291.
And at this point, was the defendant advised of his Miranda rights?
Yes, he was.
And who was that done by?
Patrolman Beatty, but I was there as well.
Did the defendant indicate that he understood his rights?
Yes, he did.
Did he make any statements at that point about stealing the truck?
Yes, he stated that he had taken the truck from the parking lot, but he had done so because he believed it to be his stolen truck that had been taken recently. The truck that he described as having been stolen from him was a different year and different color vehicle.
And did the defendant make any statements to you about the incident involving the knife?
He stated that he had not meant to try to stab Patrolman Beatty. He had been trying to get the knife away from himself so that he was not arrested with it on him.
And was consent obtained to search the camper?
Yes, it was.
And who consented to that search?
Charles Doherty.
Did Charles Doherty live in that camper?
Yes, he did.
Was he also the owner of the camper?
He told us that he was, yes.
And during the search of the camper, was the knife recovered?
Yes, it was.
And where specifically in the camper was the knife located?
Just inside the entrance.
And was any drug paraphernalia recovered from inside the camper?
Yes,
Do you recall where that was located in the camper?
just a little bit past the knife.
And while you were speaking to Brandy Thompson, did she make any statements about items that were located in her PT Cruiser?
She advised that Mr. Gillespie had two backpacks that belonged to him. She gave permission to search the vehicle and requested that we remove those bags.
And prior to that, or after that point, did the defendant also consent to his backpacks being searched?
Yes, he did.
Did you observe anything inside the vehicle while you were removing the backpacks?
Yes, there was a plastic baggie on the front driver's seat in plain view. Had a white substance inside.
And did the defendant make any statements to you about the plastic baggie containing the white substance that was located in the vehicle?
Yeah, he admitted that they were his. It was his.
I have no further questions.
Ross? Cross, Mr. Bolger.
Officer Hamilton, when you traveled on Route 28 out to this address, what was it again?
12291 State Route 28 West.
Okay, was that the first time that you'd ever been there?
I have passed there multiple times, but I do not believe I've ever stopped there.
Okay, so you never pulled into the driveway at that address?
No, I have not.
And how was it that you came to any knowledge of an association between that address and Mr. Gillespie?
Well, Ms. Thompson works at worked at the gas station directly across from the PD. I spoke with her near daily. She has told me repeatedly that she stays out there occasionally. She had also recently told me that she had picked Mr. Gillespie up when he got released, and that she was back with him.
If I understand correctly, you were relying on a recollection of a conversation with Ms. Thompson that she occasionally stayed at that address.
Also, because I have repeatedly seen her vehicle there, yes.
And you were, based on her comments, thinking that there was a relationship between Ms. Thompson and Mr. Gillespie.
Yes.
Now, when you traveled out Route 28 on that date, concerned with this pickup truck, had you located the pickup truck?
Not at that time.
And how did you get there?
We drove there.
Drove there in what vehicle?
Car 108 and car 101, I believe.
Okay, did you have lights and sirens on?
No, we did not.
When you arrived at the driveway, where did you park?
Patrolman Beatty was in front of me. He parked inside the driveway, and I parked just behind.
Were there two vehicles?
There were two.
And you parked behind Beatty.
I believe so, yes.
Were you on the driveway or on the berm of the roadway, 28?
Partially on the roadway, partially in the driveway.
What about the other vehicle?
It was more fully in the driveway.
Was it parked so as to block the driveway?
Yes.
Was that your understanding of the intention, was to block the driveway?
It was just to park there. That was the only spot.
But in parking there, it blocked the driveway.
Yes.
So do you exit your cruiser?
I'm sorry, I did not hear.
Do you exit your cruiser
I did.
immediately?
Yes.
And where do you go?
I went straight to the male that was standing by the PT Cruiser.
You say you detained him.
Yes.
For what purpose?
I was unaware if he was involved or not
Involved in what?
in a vehicle theft.
Okay, so he's standing beside the PT Cruiser, and you are detaining him because he might be involved in a vehicle theft?
I'm going to object you. I don't see the relevance to this.
Just stay.
Now, how far are you from the house or the camper right now?
Probably about 50 feet.
Can you describe the camper for us?
White camper. It has a little bit of a porch to it. Other than
How
that,
many steps?
what's up?
How many steps?
A couple of steps. I'm not sure exactly how many.
Did they give access to a door, those steps?
They gave access to a doorway.
And from 50 feet away, you can see whether the door is open or closed.
Yes.
And I take it from 50 feet away, you can see into the camper through the open door.
From the angle that I was at, I could see partially into the camper.
And you are testifying under oath that there was no cloth barrier that was in place in that doorway that
Yes.
deprived you of a view of the interior of the camper. That
Yes.
is your sworn testimony. Could you answer yes or no?
Yes.
So, take it you see Officer Beatty go up on that little porch.
Yes.
You see him enter the home, the
Yeah.
camper.
Yes.
You can't hear what he's saying.
No.
Now, having been able to view, at least from your perspective, a small portion of the interior of the camper, could you see whether anybody was in it?
No, I could not.
You did discover that there were people in it, though, didn't you?
Yes, once I was told to come over to the camper.
There were two people in the camper, weren't there,
Yes, there were.
besides Officer Beatty?
Yes.
And those two people were Mr. Gillespie and Randy Thompson.
Yes.
You had an opportunity to enter the camper finally, didn't you?
At that point in time, I did not enter the camper, no.
But finally, I mean, eventually you got in.
I went in there after we obtained permission to search from Mr. Doherty.
You did go into the camper.
Yes.
Can you describe its interior to us?
It looked like a typical camper. I do not recall the details of what the inside looked like, really.
Did it have bedrooms?
It had, I believe, one bedroom off to the right side as you enter the camper.
Now, when, if at any point in time, strike that, you're 50 feet away or so with Mr. Doherty in detention. How long is it that Officer Beatty is inside the camper before you see him again?
A short period of time, I do not know exactly how long.
Can you estimate whether it was 5 minutes or less?
Shorter than 5 minutes for certain.
And during that 5-minute period, do you have occasion to leave the company of Mr. Doherty?
I did leave the company of Mr. Doherty.
You did?
Yes.
Where did you go?
I went to the entrance of the camper when I heard yelling.
You heard yelling.
Yes.
And you're 50 feet away. What was being yelled?
I could not hear exactly what was being yelled, just yelling.
You say you couldn't hear from your distance of 50 feet what was being yelled from the camper
Yes.
that has no door.
Yes.
If it does, it's open, right? And if it had a door, it was open. Correct?
Yes.
So now you hear yelling. What do you do?
You said it had a door, but it was open?
No, sir. If it had a door, it would have been open, but there is no door.
There was no door. Okay, I'm sorry, just to make sure I
So
understood.
you're
that.
saying the camper had no door.
It did not.
Now, you hear the yelling. What do?
I go over to the camper to see if I need the help.
Okay, and what do you see?
I saw Patrolman Beatty bringing Mr. Gillespie out and Randy Thompson exiting the camper behind Patrolman Beatty.
Was Mr. Gillespie handcuffed at that point?
Yes.
Okay, so in that interval, it's less than 5 minutes. You hear yelling, and then you see Mr. Gillespie being taken out in handcuffs.
Yes.
Right. What was he wearing?
I do not recall.
And Ms. Thompson, is she handcuffed too?
No, she was not.
Did she exit before or after Mr. Gillespie?
After.
Do you know a woman by the name of either Jackie Doherty or Jackie Stonerock?
I know her by both names.
Did you see her that day in the driveway area?
I did.
You say you did?
I did.
Where was she in relation to Mr. Doherty and you as you were detaining Mr. Doherty?
She was seated nearby, further closer to the camper, but I believe it would be the outside wall of the bedroom inside.
She wasn't on the porch itself?
No, she was not.
Now, you took Ms. Thompson to your cruiser?
I did.
And you Mirandized her, and then she told you that she wanted you to search her PT Cruiser?
Yes.
She was in handcuffs at that point?
Yes.
In your cruiser?
Yes.
Did you ask her if you could search?
Yes.
Was that when she told you that she wanted you to search?
Yes.
Now, you weren't privy to conversations taking place with Mr. Gillespie, were you?
Yes, I was present for all conversations with Mr. Gillespie.
Well, was Mr. Gillespie placed in the other cruiser?
Yes, he was.
But you were present in that cruiser as he was questioned in the cruiser?
We did not question separately. After Mr. Gillespie was placed in the cruiser, he was Mirandized. And then I went back to Miss Doherty after I'd placed her in my cruiser and Mirandized her and spoke with her.
So Mr. Gillespie's questioned first and then Ms. Doherty?
They were both questioned repeatedly, multiple times, back and forth.
Now, at what point in time did you determine that the truck that was missing had been found?
After I was told by the defendant and by Miss Thompson that it was behind catch 22, we sent another officer out there and he found it.
And when did that occur in relation to the placement in the cruiser?
Several minutes after. I'm not entirely certain how long it took that officer to get there and find it.
And when did you discover that there were no outstanding warrants for Mr. Gillespie?
Later, after we brought him back to the Greenfield Police Department.
You don't recall calling into your dispatcher from the driveway while you had these two handcuffed in the cruiser?
I do not recall that.
Would there be a dispatcher log on that matter?
There should be, yes.
Okay. And you indicated that you couldn't get through to your dispatcher before you were traveling out on 28 to that property?
That is not what I indicated, no.
Well, how is it that you weren't able to check on warrant status before you traveled on 28?
Before we traveled there, we asked our dispatcher to try to locate him in Leeds. However, the dispatcher was not able to locate him immediately.
No further questions.
Redirect.
Do you, just if you do know, why was the dispatcher struggling to locate Mr. Gillespie in Leeds?
We've had this issue before, repeatedly. He is difficult to locate. We had to run him through the Indiana Leeds, and then from there, find him.
And if you don't know to check the Indiana Leeds immediately, would you have difficulty finding Mr. Gillespie in Leeds?
Indiana is one of the states that takes a long time, if you can find
And
him.
the dispatcher that you were dealing with on this date, was it a new dispatcher?
Yes.
Did they not know to check Indiana?
Not until instructed to do so, no.
And there's been repeated reference to I'll call it a curtain or a sheet, whatever you decide to call it, that was at the entrance to this camper. Did you see a curtain or a sheet?
There was some kind of something, I don't know if I would call it a sheet or a curtain, but it was hung up to the side somehow.
When you say it was hung up to the side, describe it in detail if you can.
I believe it was affixed to the top of the doorway and then held off to the side, the right side of the doorway. I do not know how it was affixed to the wall or to the ceiling.
So is it accurate to say that the curtain had been pulled back, pinned back, so the entrance, your view to the entrance was no longer obstructed?
Yes, that's accurate.
And that would have been the way that curtain appeared upon your arrival at the property.
Yes.
I have no further questions.
All right, thank you. You may step down. Next witness?
I would call Patrolman Jay Beatty.
Have you been sworn in? Yes, sir. Just have a seat there. Pull the mic over in front of you, please. Okay, Clark?
Could you please state your name for the record?
My name is Sergeant Jay Beatty.
Are you currently employed?
Yes,
Where at?
Greenfield Police Department.
And were you still employed on June 7th of 2022?
Yes,
And when you started your shift on June 7th, were you advised that Patrolman Mark Hamilton was investigating a motor vehicle theft that had occurred at the Adena Greenfield Medical Center?
yes,
And did you then respond to the hospital to assist
Yes.
Patrolman Bates or Patrolman Hamilton?
yes,
And when you arrived at the hospital, did you view their video security footage of that theft?
yes.
And what did you observe?
I observed the black PT Cruiser pulling onto the lot. I did not get to observe him actually rummaging through the vehicle when I got there. They already threw that part of the video. I observed the PT Cruiser leave the lot. A short time later, I observed who I believed to be Sean Gillespie come from the same direction that PT Cruiser left. He then got into the motor vehicle and drove the motor vehicle off of the parking lot.
And could you explain why you believe that the male that stole the vehicle, could you explain why you believe that was Sean Gillespie?
Yes, so the PT Cruiser I immediately recognized as Brandy Thompson's, who's known to frequent with Sean Gillespie. As I observed the male walking to the lot, and the male that actually got into the vehicle and drive away, while he was walking on the sidewalk and through the parking lot, he had a very distinct limp, which is very recognizable with Mr. Gillespie due to prior dealings.
So at that point in time, after you viewed the video footage, who did you suspect was involved in the theft of the vehicle?
Brandy Thompson and Sean Gillespie.
Were you were familiar with Ms. Thompson from previous dealings?
Yes.
And you were also familiar with Mr. Gillespie from previous dealings?
Yes.
Do you see Sean Gillespie in the courtroom today?
Yes.
Could you please point to him? Let the record reflect the witness that identified the defendant.
Sure.
And were you aware of where the defendant and Ms. Thompson sometimes stayed at?
Yes.
What's that address?
12291 State Route 28 West.
And is that in Highland County?
Yes.
Did you know the defendants to sometimes stay at any other locations?
Yes, numerous locations throughout Greenfield.
Would it be safe to characterize them as being somewhat transient?
Yes, very.
Did Patrolman Hamilton and yourself decide to travel to 12291 State Route 28 West in an attempt to locate the defendant, Ms. Thompson, and possibly the stolen vehicle?
Yes.
And is that location outside of your jurisdiction?
Yes.
And due to that, did you contact the Highland County Sheriff's Office to obtain permission to travel to that location?
Yes.
And did you receive permission?
Yes.
And is it normal for the Greenfield Police Department to sometimes travel outside of the village at the request or after receiving permission from the Sheriff's Office?
Yes, nearly daily.
And prior to traveling to that location, did you attempt to determine if the defendant had any active warrants?
Yes.
Were you successful?
No, we were not.
Had you checked prior to June 7th, in that time, like the 2-week window or so prior to that, had you checked to see if the defendant had any active warrants?
Yes.
And did he?
Yes.
Were they within pickup radius?
Yes, they were.
So when you arrived at that location, you weren't sure whether or not the defendant had any active warrants? Is that
Correct.
Correct.
Yes.
Now, what did you observe when you first arrived at 12291 State Route 28 West?
As I pulled in the driveway, I observed the black PT Cruiser that was in the video footage obtained from the security staff at the hospital. I also observed Charles Doherty and Jackie Doherty, or Stone Rock, standing in front of the camper.
And there's been two different last names used here for Jackie.
Yep.
I just want to clear this up. Is her maiden name Doherty?
I believe so,
And then-
yeah. I've dealt with her numerous times over the last 4.5 years, and when you talk to her, sometimes she says that she introduced herself as Doherty or Stone Rock.
So just when we're talking about the same person?
Absolutely,
Okay.
yes.
And were you aware of who owned the property at 12291 State Route 28 West?
Yes.
And who was that?
Charles Doherty.
Was there a camper on the property there?
Yes.
Were you aware if anyone lived inside that camper?
Yes.
Who lived in there?
The only person I had known to reside in the camper was Charles Doherty.
And how'd you know that?
My prior dealing with him was when his residence burnt down. I believe it's within the last year or 2 years. I assisted with that.
And After you arrived at the property, did you make contact with Jackie while she was standing outside?
Yes,
Did you ask Jackie who was in that camper?
yes.
And what did she tell you?
She advised me Brandy Thompson and Sean Gillespie was inside the camper.
Okay, after that, what did you do next?
I then walked onto the porch of the attached porch of the camper.
Could you describe this camper for me?
Yeah, I believe it was an white or an off-white color. It had an attached wooden porch to the camper.
Okay, let's talk about the entrance to this camper. Was there a door?
No.
Was there a sheet or a curtain in place of the door?
I don't know if it was a sheet or a curtain, but there was some type of clothing or cloth that was fixated on top of the doorway completely out of the way.
So this cloth had been peeled back?
Yeah, I don't know if it was nailed or pinned, but it was completely off of the door frame.
So while you were standing outside of the camper, could you see directly into the camper?
Yes,
And you did not have to move any type of sheet or curtain to be able to see inside, correct?
correct.
What did you observe while you were standing outside the camper?
As I was standing outside the camper on the porch, I observed the defendant. He had a bubble glass pipe with a lighter to the end of it fixated in his mouth and appeared to be ingesting narcotics.
And where exactly was the defendant positioned?
He was just inside the doorway to the left.
And from where you were standing outside the camper, you were able to see that location?
Clearly.
correct? Once you observed the defendant in the camper appearing to consume narcotics, what did you do next?
I immediately advised the defendant he was under arrest. I entered the camper at that point.
Why did you decide to enter the camper to place the defendant under arrest?
He was obviously in possession of drug paraphernalia and appeared to be ingesting or inhaling drugs at that time.
And were you concerned that the defendant would attempt to dispose of the paraphernalia or possibly narcotics if you did not immediately enter?
Absolutely.
Why did you have that concern?
Due to multiple prior dealings with Mr. Gillespie regarding foot pursuits with him while he's had active warrants, he has disposed of or attempted to dispose of drugs or drug paraphernalia numerous times over the last several years.
And this glass pipe that you observed in his mouth, could you describe the appearance of that pipe?
Yeah, it was a clear glass bubble pipe with burn residue.
And what would such a pipe be used to consume in your experience?
In my experience, methamphetamine.
So after you entered the camper, advised the defendant that he was under arrest, what happened at that point?
He immediately threw the glass bubble pipe, attempting to dispose of it.
What happened after the defendant threw the pipe?
I immediately observed a fixed blade on Mr. Gillespie's lap. He then grabbed that blade with his right hand and turned towards me, swinging the blade in my direction.
After he swung the blade towards your direction, what did you do in response?
I immediately was able to gain control of his right arm. After a brief period of seconds, I was able to get the knife away from Mr. Gillespie. Then, after a short struggle, I got him to his stomach and placed him in hand restraints.
Was anyone else inside the camper while this was going on?
Yes, Brandy Thompson.
Could you describe her demeanor while this was unfolding?
As we were wrestling or in a physical altercation, whatever you want to call it, she was screaming the entire time.
So after you finally managed to gain control of the defendant and place him under arrest, what did you do after that?
As soon as I got him in cuffs, I stood him up and I advised him to walk out of the camper. I then escorted him out of the camper. I then advised Brandy Thompson to immediately exit the camper as well.
And after the two subjects were removed from the camper, did you obtain permission to search that camper?
Yes,
And who gave you consent to search?
Charles Doherty.
And it's your testimony that you knew him to be the resident of the camper?
Correct, that's what he advised as well.
And you also believe he was the owner of that camper?
Yes, that is what he advised us.
Did you recover the knife during your search of the camper?
Yes,
And this was the same knife that the defendant had swung at you?
yes,
And where in the camper was that knife located?
just inside the doorway.
Did you recover any drug paraphernalia from inside the camper?
Yes.
And where was that recovered from?
The pipe that he had thrown landed just maybe a foot in front of the knife that I located on the floor as well.
Okay. So, once and just so we're clear, the defendant, was he placed in your patrol vehicle or patrolman?
He was
Hamilton?
placed in my patrol vehicle.
Okay. And once the defendant was in your patrol vehicle, did you question him about the incidents?
Yes, I waited until Patrolman Hamilton had Miss Thompson in his vehicle. I then instruct him to come over here and witness the Miranda and questioning of Mr. Gillespie.
So did you, before you started questioning the defendant, did you advise him of the Miranda rights?
Yes,
And did he indicate that he understood his rights?
yes,
Did the defendant make any statements to you about the stolen truck?
yes. I first questioned him on the vehicle. He advised that he had a vehicle that was similar to that truck that he had stolen that day. He advised that it was stolen from another residence in Greenfield. When he observed it, he believed that was his truck that had been stolen prior, until later when he got Miss Thompson, she advised him it was not the truck that was stolen. It was later determined it was a different color and different year of the vehicle that he had stolen.
Did the defendant make any statements to you about the incident with the knife?
Yes, he first advised that he was not attempting to stab me. He advised that he just wanted to get rid of the knife because he did not want to be arrested with it.
So after your conversation with the defendant, did you speak to Brandy Thompson?
Yes.
What did Ms. Thompson have to say?
Ms. Thompson advised that she was in a probation meeting here in Greenfield. She advised that Mr. Gillespie had control of her vehicle while she was in her meeting. After she completed her meeting, she got out. Mr. Gillespie pulled up to pick her up. She then got in the driver's seat. Mr. Gillespie then advised her that he had obtained their stolen truck back, and then instructed her that it was behind Catch 22. Ms. Thompson then drove to Catch 22, or behind Catch 22 rather, and observed the truck. Then advised Mr. Gillespie it was indeed not their vehicle. She advised they then got into a verbal argument and then went out to the address on 28.
And was Ms. Thompson, was consent obtained from Ms. Thompson to search her PT Cruiser?
Yes.
And did she mention, before you searched the vehicle, did she mention that the defendant had 2 backpacks in there?
Correct.
Did you ask the defendant for permission to search those backpacks?
Correct.
And did you find anything noteworthy during your search of the vehicle?
Yeah, as soon as we began searching the vehicle, we observed a cellophane or plastic baggie with an unknown substance inside of it.
And did you question Brandy Thompson about that unknown substance in the vehicle?
Yes.
What did she tell you?
She advised she knew nothing of the sort.
Did you ask the defendant about the substance that was located?
Yes.
What did he tell you?
He advised that all the drugs inside the vehicle were his and that the narcotics that we collected was methamphetamine.
Did he make any further admissions about what he'd been using that vehicle to do?
Yes, he advised that he's been selling methamphetamine out of that vehicle in the prior weeks.
I have no further questions of this witness.
Ross?
Officer Beatty, where did you park your cruiser as you approached the property that we're concerned with?
I pulled into I was located in the driveway.
Did you leave it at the head of the driveway?
No, I was pulled into the driveway fully.
Where did you park in relation to the PT Cruiser?
Directly behind the PT Cruiser.
Did you see anybody that you could recognize in the near vicinity of that camper?
In the camper, yes. I observed Charles Doherty and Jackie as well.
You say there was no other person that you recognized?
Not outside at that time, no.
Did another person appear?
I believe there was another male in the very back of the property. I believe there was a burn ring or a fire circle. He was sitting on a bucket.
Did he come into the situation?
No,
there,
not at all.
camper? Now, apparently, you're now recalling that there was some kind of cloth draped in proximity to the doorway.
I did not say draped.
Was it on the wall?
It was pinned to the wall at the outside of the camper, yes.
In what relation to the door?
I believe it was above it and to the right, and the top of it was pinned as well as the bottom of the cloth was pinned as well.
Now, you say as you got up on the porch and you looked in.
Absolutely.
Did you speak to anyone inside?
I immediately advised Mr. Gillespie that he was under arrest after I observed him.
Where were you when you said that?
Standing on the porch.
You hadn't entered the property or the camper itself?
No, I had not.
After you told him he was under arrest, I assume you did go into the camper.
Yes.
Now, he is seated, isn't he, when
Yes.
you walk in?
Yes,
There is a half wall there, isn't there?
correct.
Do you go around the wall?
Actually, I believe when we first got into a physical altercation, it was over top of that wall.
So you never, in your initial approach to Mr. Gillespie, having told him that he was arrested, you didn't go around the wall?
I'm sorry, I was distracted from your beginning of your question.
Let's go back.
Okay.
You see what you think is a criminal behavior on the part of Mr. Gillespie. You got a pipe up, right?
Yeah, he had it in his mouth with a lighter on the end of it, yes.
Okay, what hand was he using to light the pipe?
I do not recall.
So, you're only a couple feet away from him, even though you're standing outside on the porch.
Correct.
Is that right? You reach for him after you tell him he's under arrest.
Reach for what?
Reach for him.
Absolutely, yes.
Okay, you reach for him over the half wall.
Actually, no, I did not reach for him over the half wall. He was actually swinging the knife at me as I was coming in, and I met his hand over top of the wall.
So he's bringing a knife up over the half wall as you're coming in the door. Is that right?
Correct.
Where is Brandy Thompson, can you tell?
She is seated to the left of Mr. Gillespie on the couch as well.
And as you enter the camper, where is Jackie?
She's outside the camper. She is where I left her, I believe,
And where did you leave her?
in front of the camper.
So, does Mr. Gillespie at any point in time, while you are able to observe his hand on a knife, does he at any point in time stand up?
I believe when we went hands-on with each other, when I grabbed hold of his hands, when I pulled, he swung the knife towards me, I went hands-on with that arm. Maybe in the physical altercation, he maybe stood up for a half second until I placed him back down.
But he's seated when you first see it.
When I first saw him, yes.
He's coming up over the half wall
Yes,
in his right hand.
yes. I would not say that's an accurate description of his hand movement, though.
Well, it's not being recorded.
Okay.
Now, you say he flung the lighter, right?
No, that's not what I said. I said he threw the meth pipe.
What happened to the lighter?
I have no idea.
The lighter was in his right hand.
Okay, well, I assume he dropped that then.
You assume you didn't see it.
No, I was more focused on the meth pipe.
No further questions, Ron.
Your Director?
No questions?
I just have a couple, Officer, Sergeant Beatty. You mentioned that Mr. Daugherty lived there and had been a previous fire. Was there a house on this property that burned? So he was living in the camper?
I'm not sure, so I know it was maybe a trailer, I'm not sure what type of house it
So
was.
something else where was his residence that was burned?
Yes.
And he was living there?
Yes.
There's no indication anyone else was living there besides him?
No, he did advise me though that they frequently come out and sometimes stay the night, but they did not have a residency there.
All right. All right, thank you. All right, any questions about what I asked,
No, Your Honor.
Mr. Bolger?
I understand that you've had contact with Mr. Doherty surrounding the destruction of a residence on that property. Is that right?
Correct.
Okay. Do you know who actually owns the property?
I did not, I've not looked it up. I was advised by Mr. Doherty that he owned the property.
That's the only information you have on that issue.
Correct.
No further questions.
All right, you may step down. Thank you.
Thank you.
Any other witnesses?
No, Your Honor.
Stay rest.
Yes, Your Honor.
All right, stay rest. Mr. Bolger, any witnesses?
Your Honor, I'm going to call Mr. Gillespie.
All right.
Take the stand.
Yes, sir.
Gillespie, if you would, wait, just hold on a second. Would you face me and raise your right hand the best you can? You solemnly swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth. Have a seat right there. Now, Mr. Gillespie, before you testify, I'll mention your attorneys talked to you about this, but I need to put it on the record. You do have a right under the Constitution of both the federal Constitution, the Fifth Amendment, as well as the Ohio Constitution, not to testify in court because anything you said could be used against you if it's favorable to the state. Now, this is a suppression hearing, and so if you testify in this hearing, what you say is not going to be admissible by the state against you at trial unless you testify at trial and you testify differently. So I just want you to be aware that for purposes of the Fifth Amendment, anything you're saying today could be used against you in this proceeding for this issue only, but it would not be used against you at your trial. And so you understand that?
Yes, sir, I
All
do.
right, and based on that, you do wish to testify then?
Yes, I do.
Okay, that's fine. All right, thank you. All right, Mr. Bolger, if you want to elaborate any more on that, go ahead, but I wanted to get that in the record.
Correct. Mr. Gillespie, give us your full name.
My name is Sean Michael Gillespie.
And Mr. Gillespie, you recall this day that we're concerned with, I take it?
Clearly,
How long had you been at the camper before you realized there were law enforcement officers on the property?
well, enough time to eat about 5 or 6 oranges, set my knife down on my lap,
Well,
continue to smoke my bubble but for about 5 minutes, and then they pull up.
Okay. Could you give us an estimate in terms of minutes rather than oranges?
What was the question again? From the time I took the truck?
No, from the time that you arrived at the camper, how long was it before the officers arrived?
About, I'd say 45 minutes or longer.
Okay.
Approximately 45 minutes to an hour.
Okay. Were you living at the camper?
No, sir, I wasn't. I was staying at a hotel in Washington Courthouse because of the insurance company paid for the house being burnt down, paid for our stay.
Now, where were you located inside the camper?
Literally at the threshold of the door, approximately 12, 16 inches just inside the doorway.
And was at the time that, in those minutes before, rather, you realize there is an officer on the porch, what, if anything, blocked the view through the door to where you were sitting?
Well, I can tell you this. The curtain that's been up there, and it is only been up there since the camper has arrived. We put the curtain up to keep the cold air from coming in. And then also, when we want the door open, we pull the curtain down so I can use my privacy and to block the wind from coming in from where I sit there and smoke.
Was the curtain up or down at the time that you realized there was an officer on the porch?
The curtain was down. I pulled it down because I sat down to smoke. And with the curtain being down, it don't blow my flame from using it to heat up the bottom of my bubble. And with that being said, I am sitting there talking to Brandy, smoking my bubble. I hear Mr. Gillespie step out here. I turn and look at him, and it's Officer Jay Beatty that's standing here.
How could you see him?
He is, may I stand up?
Sure.
He is telling me like this, stuffing the curtain behind the door, that the door is attached to the door, residence. It is pulled open and there's a decking. We have a board that goes down and slips between the boards to keep the door propped open. The 2x4s running this way. So he is stuffing the curtain behind there and telling me, step out there. Oh, you're smoking a pipe, Mr. Gillespie. And I go to set the pipe down, he snatches his hand immediately.
What, if any, manipulation had happened to the curtain before you could see the officer?
What?
What had happened to the curtain that allowed you to see the officer?
He was pulling it open, stuffing it behind the doorway to keep it open, talking to me at the same time he's stuffing it. And right beside him is Jackie Stonerock, standing there on the porch, looking at me bright-eyed and bushy-tailed.
Okay. I have no further questions.
Ross?
Mr. Gillespie, you mentioned several times that you were smoking a bubble. Is that accurate?
Accurate.
What were you smoking out of that bubble?
Methamphetamines.
Okay. And you mentioned that this curtain or sheet was in place to keep the cold air out.
In the wintertime, that's what we used it for. I pulled it down because I was smoking, and I didn't want the wind to come in the doorway. The curtain has been there, hung up, and it's on the inside of the threshold about, I'd say, 6 inches. There's a screen door, then the actual door, and then the curtain.
Mr. Gillespie, have you ever ran from law enforcement before?
Yes, I have.
Are you on probation right now?
No, sir.
No further questions.
Redirect.
No, Your Honor.
May step down. Any other witnesses?
No further witnesses, Your Honor.
Rebuttal?
No, Your Honor.
Argument?
Thank you. There are a couple different issues I think that need to be addressed here. I'm just going to go through them in the order that they occurred. So the first issue is whether it was proper for Patrolman Beatty to enter that camper and place the defendant under arrest. The defendant just took the stand and testified that he did not live in this camper. So I would argue that based upon that, he doesn't even have standing to raise a Fourth Amendment argument that this was an unlawful arrest inside that camper. Also note that Patrolman Hamilton and Patrolman Beatty have both testified that this sheet or curtain was already pinned back when they got there. They didn't peel it back. They didn't manipulate it. Patrolman Beatty, while standing outside, could see straight into that camper, and he could see the defendant hitting a meth pipe. I would argue at that point that exigent circumstances existed to allow and to warrant Patrolman Beatty to go inside that camper and immediately place the defendant under arrest, particularly in light of the fact that as soon as Patrolman Beatty said you're under arrest, what is the first thing the defendant did? He threw the meth pipe. He's already starting to dispose of evidence. He's done so in the past. He's ran from officers in the past. I don't think there's any doubt that it was proper for Patrolman Beatty to enter that camper and place the defendant under arrest. Now, if by chance the court would determine that Patrolman Beatty's actions were improper, there are numerous cases which basically stand for the proposition that even if there is a Fourth Amendment violation, that still does not privilege the defendant to assault an officer. A defendant can try to block a doorway or stop an officer from coming in if there's an unlawful arrest in progress, but once that officer is in, the defendant cannot assault them. And there are numerous cases that I can provide that stand for that proposition if and when the court would like those cases. The next issue here is whether or not the search of the camper was proper. I don't think there's any question that it was. The one person who was known by officers to reside in that camper was Mr. Doherty. He consented to a search of that camper. The knife and drug paraphernalia were then recovered from, just inside the doorway, what I would call the common area of the camper. So based on that, I would say that the search of the camper, there's no question that it was proper. The next issue to address is the search of the PT Cruiser. This is Brandy Thompson's vehicle. Brandy Thompson consented to the vehicle being searched. She mentioned that the defendant had 2 backpacks inside the vehicle. Before officers entered the vehicle, they asked the defendant for permission to search the backpacks. He granted permission. Officers approached the vehicle, and in plain view right there on the driver's seat, they see a baggie of meth. Brandy Thompson says, "Not mine." The defendant says, "Yes, it's mine. And in fact, I've been driving that vehicle around and selling meth out of it." So that brings me to the final issue, which is the statements and the admissions made by the defendant. Patrolman Hamilton and Patrolman Beatty both testified that they were standing there when Patrolman Beatty advised the defendant of his Miranda rights, which he indicated he understood. After that point, the defendant proceeds to make admissions and various statements. So based upon that, it's the state's position that none of this evidence should be suppressed. There's no merit to this motion, and I would ask that it be overruled. Thank you.
Thank you, Mr. Bolger.
Your Honor, I'll be brief. The primary question.
Stand when you address the court, please.
Yeah. The primary questions the court needs to address has now been subject of a credibility determination. What we're contesting is that the officer had no right to remove a visual barrier to gain view of the interior of a habitation. Whether Mr. Gillespie is a tenant, a resident, or a guest, he would have standing on this issue. He would have a reasonable expectation of privacy in this situation as long as he was in consented use, and there's no indication he wasn't. Mr. Doherty was right there. He's the claimed owner, and he apparently advised that they're there. So there's the standing issue, I think, is a red herring, but it is a question of whether or not it was an actual removal of an opaque curtaining of the doorway in order to gain view of Mr. Gillespie and what he admits was his activity at that time, which was smoking methamphetamine. That seems to be, and all other issues pivot off of that determination, and that is in your hands.
Very well.
No, sir.
All right. Well, court takes, looking at this, I think that the law is fairly clear. And I would start with agreeing with the state that the defendant has not shown any standing to object to the search of either the camper or Ms. Thompson's PT Cruiser. He has testified that he was not living there. He was living in a hotel in Washington Courthouse. It indicated he'd been there maybe 45 minutes. He claims no ownership of the property. He demonstrated no expectation of privacy, merely being a guest in someone's home on a temporary basis, in this case about 45 minutes, if that's according to him, does not create an expectation of privacy. If I have dinner guests over for an hour, somebody enters my home, law enforcement enters my home, they don't have an expectation of privacy in my home because they're my guest. So although there's some testimony that he and Ms. Thompson had stayed there previously, testimony does not establish they had been recently. There's no indication that they had any property inside of the camper other than drug paraphernalia and possibly and likely methamphetamine. So the court will find defendant lacks standing to object to the search. However, even assuming for purposes of the motion that there were standing to object, the court finds that the officer's actions were proper. The Fourth Amendment guards against unreasonable searches and seizures. He was there investigating a crime. He had a reasonable suspicion, if actually probably probable cause. In fact, in the court's opinion, he did have probable cause, believed the defendant had stolen the vehicle. So he had a right there to be there. And according to his testimony, that curtain was not drawn. The defendant claimed it was. The court's view would be that the officer's testimony, both officers' testimony, is more credible than the defendant's and would indicate to the court, and the court would so find that there was no curtain or sheet or cloth or whatever it is as described in all those ways, obscuring the view into the camper. Further, the officer had been directed there by other persons on the property that that's where Mr. Gillespie was, and he wanted to talk to him. And so he was in a place where he had a right to be, and while in that place was able to see in plain view defendants smoking methamphetamine, what he believed to be methamphetamine in the bubble pipe, which has been testified today was what in fact was going on. And that is a felony under 292511 of the Ohio Revised Code, and also it would be a misdemeanor drug paraphernalia. The citation escaped me. It is 2925 something. And so that gave him the right to arrest the defendant, take him into custody. So the arrest was valid. Furthermore, the search after the arrest could have been conducted pursuant to the arrest, but because of there was a valid arrest and there was evidence he had seen that had been thrown away, so he actually didn't need consent to go back in. He could have searched it incident to arrest. However, they did also obtain consent of the owner of the property, at least the claimed owner of the property, Mr. Doherty, so that's a valid search. Same thing with the vehicle. Again, he didn't have, Ms. Thompson's vehicle, he didn't have standing to object to it. He did have standing with regard to the backpacks, but the testimony is that he consented to that. He did not deny that in his testimony. The officer indicated he did consent. Also, Ms. Thompson had consented, so everything that was done there was valid. So based on that, the court overrules the motion in total. All right. Now, today is the 6th, and this trial is set for Monday the 17th, and I'm going to be gone all next week, so have you provided your discovery?
I've given the names of 4 prospective witnesses.
Okay, so discovery is complete. There are no other motions pending, correct?
When did you provide that?
I have something in the file, supplemental discovery, actually, that's all.
I labeled it supplemental discovery because I didn't know whether prior counsel had provided this stuff. Okay, it was provided.
August 17th, the
Yes.
name Brandy Thompson, Jackie Stonerock, Charles Doherty, I think that's misspelled, and Scott Nicely.
We don't have a copy of that. Did you ask the clerk to serve us, because that does not work?
We served it by email according to the proof of service, so you might want to check your email on that date of August 17th.
So you can get a copy out of the file. All right, so we're going to go trial then on the 17th.
I have not discussed the case at all with Mr. Bolger. However, the state has been apprised by the chief officer in this case, Sergeant Beatty, that when we did subpoenas, which was back on September 26th, that he has a trip scheduled for the 17th that he has already paid for and cannot get a refund on. So we would ask for a motion to continue that date. And this is the first time the state's requested a motion to continue this case, which was just indicted in July.
Mr. Bolger, any objection?
Mr. Gillespie is in custody.
I'm sorry?
I
He
said
is in
Mr.
custody, I know.
Gillespie is in custody, so I
Right.
don't think I can join in the motion. I will remain silent. I will indicate to the court that he will be pleading to the drug counts in the indictment. And that will leave, I believe, two counts for trial. And that would be the...
It'd be, so pleading to count 3,
Yes,
but not count 1 and 2.
right.
All right. Originally, this case was set for jury trial on August the 25th. And I believe that it was continued at, when Mr. Bolger came into the case, if I'm not mistaken. Mr. Armentrout had been representing him.
Right. He requested a continuance of it on August the 11th.
Pardon me?
He did request a continuance on August the 11th.
Okay. August the 11th, okay. And so that waived the time until October the 17th.
But, it's got to be in the same...
And I believe there was some discovery as well going on there. What was his date of arrest? The date of the offense was June the 7th?
Yes, Your Honor.
You proceed.
All right, so, you say, Officer Beatty, you say you're going, how long is your trip?
I will be leaving the 15th, and I'll return on the 20th.
All right, and you say it's a trip that you paid for
Yes, sir, about 7 months ago.
7 months ago? All right. All right. Well, let's get the calendar. Court's going to find that the defendant has waived the speedy trial time when he requested his continuance, and based upon the fact that at the time of that, unknown to the court, that Sergeant Beatty already had a conflict. It's clear he's a necessary witness, so the court will find that waiver continues to apply. But even if it doesn't, that pursuant to 2945.72H, the court can grant can extend the time on a reasonable basis, reasonable cause, and the court will find that that's caused because the conflict with Sergeant Beatty's schedule was created by the request of the defendant to continue the case originally from the original trial date. So with that being said, let me look here. Can't do that one because he's going to go to trial. Let's see if we have some set for the. Okay. Oh yeah. We're doing a Zoom conference on Krebs today, right? Isn't it? Yeah, it's on the. It's on the calendar.
Oh, it's for today?
Yeah. Because we have him set for 24th and the 27th, because those are two separate cases, right?
Yeah, 2 separate.
All right. Depending upon the situation in that case, because we have a special prosecutor, we don't have any other head cases other than that one set. He pled, didn't he?
I think we talked about it. Who?
Juan Anderson?
He is not pled, and I'm prepping that case right now.
Okay. Well,
Mr. Van Noy does not want to try that case, but he has not been able to convince his client yet.
all right. How about November the 7th, Mr. Bolger? Do you have that available?
I believe I am available on the 7th,
Okay.
and the sooner the better.
We have some cases set, but they're all more recent cases, and I don't think any of them are in custody. Mr. Yoakum pled yesterday. Mr. Anderson is a fugitive. There's a Bradley Hickson and Rebecca Martin. And those are more recent cases, so we'll continue the case then to November the 7th at 8 a.m. The court will find, as I said, that it's a reasonable continuance and a reasonable basis for continuing or extending the speedy trial time. And there also may have, I know there's been some discovery, plus the motion to suppress also, court finds tolls the case. And it was said today that there was possible time for both parties and the court. And so that also extends the speedy trial time for that period from the filing of the motion until this disposition today. So again, the court will extend and find that the speedy trial time has been told, and to the extent that it has not been told from today forward is extended pursuant to the order of the court for a reasonable good cause, and there would be no prejudice caused to the defendant. All right, now, anything else then from counsel?
No, Your Honor.
Bolger?
No.
Do you have anything else? All right, thank you. All right, are you Austin Fraley Reynolds?
Yes, sir.
All right, this is case number 22 CR 93, State of Ohio versus Austin Fraley Reynolds. This hearing is a bond review being conducted by Zoom. Prosecutor Collins and Assistant Prosecutor King are both in the courtroom. We just finished a hearing. We have another one immediately after this. The defendant's appearing from the jail, and then also appearing is appointed counsel Danielle Witt. This is a review hearing. He is charged with failure to register as a change of address as a sex offender. Court set bond without counsel present, so pursuant to Criminal Rule 46, this is a review hearing. Bail is set in the amount of $5,000. Ms. Witt, is there anything you would like to say regarding the matter of bond?
Yes, Your Honor, we do ask for a reduction. I believe at the preliminary hearing, the bond was reduced to $2,500, and in doing a quick search, do not see where Austin has any kind of criminal history, at least in this county. And you can speak to as his ties to the community as well.
Right. On behalf of the state, either of you wish to be heard on that?
Well, Your Honor, he does have a prior criminal history, which is why he's a registered sex offender. I'm not sure of any ties to the community. He was arrested in Cleveland. He had been here originally, had registered an address here, took off, ended up allegedly maybe in a mental hospital somewhere. That may have been in Columbus, and then was found in Cleveland. I'm not sure what his ties to Highland County are, other than he registered here and then failed to register that he was leaving here. So based on that, I would ask the court to leave the bond in place.
I have misplaced his appointed counsel form. Deputy, I know you faxed us up his appointed counsel or disclosure form, and it's not in the file, but if you still have it out there, if you would fax it up again, please.
Absolutely.
I was just looking through here. I think what happened is in all the cases I did yesterday, I think I got it stuck in another file, so it'll probably show up here in a day or two. But the reason I bring it up is I believe, as I recall, Mr. Reynolds, you listed yourself as homeless. Is that correct?
Yes, sir.
Yeah, that's what I thought. Well, based upon what the state has indicated about the lack of ties to community and his wandering around this state and to the great state of Cuyahoga, as they call themselves, the court finds that a bond is necessary to assure his appearance, and $5,000 is not unreasonable. So the bond will remain the same. All right. Thank you.
Okay, thanks.
All right.
Conference call on this is ready.
All right, case number 21 CV 185, Highland County General Health District versus Susan Hatfield. Present on behalf of the state, or on behalf of the plaintiff is Prosecuting Attorney Collins, Assistant Prosecutor King, Mr. Webb from the Health Department, and you are Susan Hatfield.
Yes.
All right. This is a hearing, I believe, status. The court had issued a judgment entry granting injunctive relief back on January 21 of this year. There had been a contempt motion filed that was continued in progress from June 8th to June 22nd. And then if we had a hearing then, it continued to July, that was July 12th and into the 3rd. I believe there was some issues, personal matters required that to be continued. And looking at my notes here, the last time we were here, was June the, yeah, it was supposed to be cleaned up by July the 13th. No, that wasn't the last time. That was June 22nd. Said to be cleaned up on July 13th. September 8 hearing. Here we go. I did find the defendant in contempt. Sentenced her 30 days in jail. Gave her 30 days to purge herself for the purge hearing. That's the purpose of today's hearing. All right. So, has the defendant purged herself of her contempt?
Your Honor, according to the pictures and Mr. Webb's statements, pictures that he took at 5 o'clock yesterday evening, no, she definitely has not.
All right. So, Ms. Hatfield, why weren't you, you understand you had 30 days. I told you you had 30 days, and you have not cleaned it up.
He was out there yesterday, and I told him the dump, we was taking all the dump stuff down to the trash thing, because it's open on Wednesdays, and which then was all dumped. And my front porch is cleaned off like he asked me to clean it off, and my carport, we're doing it now in my carport.
So you don't have it cleaned up? All
Yeah,
right.
my front porch is done like he asked me to do it yesterday.
Well, that's not, you were supposed to have the entire thing done. You don't have it
Trash is
done.
dumped
All right.
like he asked, and which he seen the barrels on the wagon get ready to go down to the dump when he came out.
Well, but there's still stuff there that you still have to clean up, right?
It's not trash, it's wheelbarrows, our personal stuff. It's not trash.
Well, it's amazing. There must be some sort of underground grapevine down there, because I hear the same story from everybody. Everybody comes in here. I just had one earlier this morning.
That's not
They were
trash.
there. You be quiet. They were there yesterday afternoon, and right after they left, now got it all cleaned up. And you come up with the same thing. Here it is. You've already been found in contempt. I ordered you to serve 30 days. I gave you 30 days to clean it up. You come in here and tell me, well, I got it cleaned up yesterday. So it's the order of the court that you, finding the court, you have not purged yourself of contempt. So you are to report to the jail to serve your sentence on October 23, that's a Friday, at 4 p.m. Now, if you feel that you've got it cleaned up, and if the health department and the plaintiff, through counsel, file written notice with the court that it's cleaned up, that you've purged yourself, and if they file that by October, I need to have a couple of days to be able to act on it. So if they file that by the, wait a minute, I said the 23rd, it's the 21st, I'm sorry, not the 23rd, 21st. 23rd is a Sunday. Friday, October 21st. If they file a written notice, and the court will suspend the 30 days on the condition that you pay the cost within 30 days after that. But It ain't gonna be any, calling me up that morning and say, oh, I got it done, Judge. Nope, it's not happening. So, and effectively, you've got until the 19th to get to them, and you're gonna have to convince them. And if you don't convince them and they come to the court and say, Judge, she's complied, then you report to jail, on the 21st at 4 p.m. I'm done with this kind of, last-minute, crap's going on. All right? So give her an assignment, or give her an assignment notice to report to the jail. All right. So just step around there and get your assignment notice. All right, Mr. All right, case number 22 CR 126, State of Ohio versus Ryan L. Wilson. This hearing was rescheduled today from yesterday afternoon, pretrial. This is a Zoom hearing. Whoops, I've lost the prosecutor. Oh, we're waiting for her to sign back in. The defendant is appearing, and you are Ryan Wilson, appearing on the screen that has Ryan's iPhone in it.
Yes, Your Honor.
All right, and Mr. Fox, Mr. Wilson's attorney, is appearing by Zoom. And Mr.
Yes.
Fox, you and your client both stipulate to this hearing being conducted by Zoom remotely rather than him being required to appear with counsel before the court.
We do.
You're all right with that, Mr. Wilson?
Yes, Your Honor.
Okay. Ms. Collins, can you send a note to me, or a text or something to Ms. Collins, tell her to sign back in?
I already have, and she's
Okay.
attempting to. I just wanted to let you know that.
All right, thank you. While we're waiting on her to log back in, I was not aware at the time we had the hearing yesterday that there had been a motion to withdraw as counsel filed. It hadn't come up yet, as well as a motion to continue. I'm guessing, my assumption is that since that motion was filed, there has been a change in the circumstances, that that's no longer an issue, Mr. Fox?
Correct, Your Honor, and I will withdraw both of those motions.
All right. And you're in agreement with that, Mr. Wilson, that the motion to withdraw and continue be withdrawn?
Yes, Your Honor.
All right, thank you. All right, the record reflect Ms. Collins has now been able to sign back in, so we did take care of the preliminaries on that motion for withdrawal of counsel and the stipulation of this hearing being conducted by Zoom. Mr. Wilson is charged with 3 counts of aggravated trafficking of methamphetamine, 1 of vicinity to school, 3 counts of aggravated possession of methamphetamine, and 1 forfeiture specification. And I believe we have a trial date in October or later this month. I can't remember, 24th. Now, I did receive a fax plea form. Well, actually, Ms. Collins has signed it originally. And this indicates, Mr. Wilson, you're going to withdraw your not guilty plea and plead guilty to, looks like counts 1, 3, and 7. Now, I'm going to hold this up to the screen there, and you see there the plea of guilty with your name and case number on it, and the counts you're pleading to.
Yes, Your Honor.
All right. On page 4 of this form, there's a sentence at the very top of the page that says, I enter this plea voluntarily. Immediately below that, I see the original signature of Ms. Collins and a fax signature of Mr. Fox. Then there's a box there that says Ryan Wilson electronic signature. So I'm going to hold that up to you. And you see that there? I'm sorry, it shows your electronic signature.
Yes, Your Honor.
And did you authorize Mr. Fox to place your signature on this agreement?
Yes, Your Honor.
And did you have a copy of this to go over before you signed it?
Yes, Your Honor.
And did you have an opportunity to talk with Mr. Fox and have him answer any questions that you may have about the agreement?
Yes, Your Honor.
And when you signed it, did you understand that it's an agreement to plead guilty, which means there's not going to be a trial, and the next step in your case would be a sentencing hearing?
Yes, Your Honor.
And you feel you've had enough time to fully consider this matter before making this decision?
Yes, Your Honor.
And are you entering into the agreement to plead guilty to these counts voluntarily?
Yes, Your Honor.
And you still want to do that here this morning?
Yes, Your Honor.
All right, now the agreement states on page 1 that you're going to plead guilty to count 1, aggravated trafficking of methamphetamine in the vicinity of the school under 2925.03A1, a second-degree felony. Count 3, aggravated trafficking in methamphetamine under 2925.03A1, a second-degree felony. And count 7, the forfeiture specification under 2941.14.17 of the revised code. It says that you understand that on this first page that I'm looking at what the maximum penalties are for these 2 offenses. They're the same degree, second-degree felony. And so under the law, first of all, persons convicted of these offenses are required to be sentenced to prison to a mandatory term. The judge has no discretion. The judge has the authority under the law to sentence a person convicted of these offenses to a minimum mandatory term of 2 years as the minimum, up to 8 years as the maximum that the judge can impose. And that is a minimum sentence that must be served. Whatever that number is, all of it has to be served. There's no early release. There's no good time credit. You get jail time credit, but there's no reduction in the sentence. Now, under a law went in effect a couple years ago called Reagan-Toast Law, and that's in your plea form. The Department of Rehabilitation and Corrections has the authority under the sentencing law that these offenses fall under to extend a term of incarceration set by the judge for up to 50% of whatever the sentence was by the judge. They make that decision. The court has no involvement with it, and they make it based on their analysis of the history and so forth. So what that means is that since the maximum that I could sentence you to on each count is 8 years, effectively, if that were the sentence, the DRC could increase it to up to 12 years. Now, under that law, they can only do that on one of the charges. And so even though you have 2 F2s, the maximum sentence of those is 16 years if they're added together, but only one of those could be extended. And that would be a maximum of 4 years if a sentence on both was 8. So that means that the maximum sentence could be 16 years actual time ordered by the judge, and then it could be extended for an additional 4 at the discretion of the Department of Rehabilitation and Corrections. Do you understand that?
Yes, Your Honor.
Now, there's also a fine of up to $15,000, and there's a mandatory fine on each count of $7,500. There's also a license suspension of 6 months to 5 years. And you understand that?
Yes, Your Honor.
Now, other than this indictment, are you facing any other pending felony charges?
No, Your Honor.
Now, I believe you are on probation or community control in case number 21 CR 173. I believe that went into effect on January 6, 2022. Are these offenses alleged to have occurred after that? No, they're alleged to have occurred before. All right.
Yes.
And so, under the law, under your probation in the other case, conviction of a crime is a grounds to revoke you, but because these offenses are alleged to have occurred, if you plead guilty, after or before that date, they would not be a violation. And so what would happen in that case, just so you know, is if you plead guilty or are convicted after a trial and sentenced to prison in this case, your probation or community control in the other case will be told while you're incarcerated, and then when you release, it'll be reactivated. Okay, you understand that?
Yes, Your Honor.
All right. Now, and again, the law provides in this case that to these 2 charges, I cannot grant community control or probation. I have to sentence you to prison. You understand that?
Yes, Your Honor.
All right. Now, count 1 alleges that on or about August 12, 2021 in Highland County, Ohio, you and Sierra Nicole Wilson did knowingly sell or offer to sell methamphetamine, a Schedule II controlled substance, an amount equal to or exceeding bulk amount less than 5 times bulk amount in the vicinity of the school zone, a violation of Section 2925.03A1. And so that's the charge of aggravated trafficking of methamphetamine in the vicinity of the school zone. And then count 3 alleges that on or about September 2, 2021, Highland County, Ohio, you and Sierra Nicole Wilson did knowingly sell or offer to sell methamphetamine, a Schedule II controlled substance, an amount equal to or exceeding 5 times bulk amount, but less than 50 times bulk amount. Also a violation of 2925.03A1. So they're the same statute, they're the same degree of felony, because in count 1, it was committed allegedly committed in the vicinity of the school zone, and in count 3, it exceeds 5 times bulk. It's a higher amount. So that's the reason that they are worded differently, but they're the same section number and the same penalty. You understand that?
Yes, Your Honor.
Now, Mr. Wilson, do you understand what it is you've been charged with having done in those 2 counts, what the state said you did, where, when, where, and how they alleged you did it?
Yes, Your Honor.
And have you discussed the nature of those counts, the evidence in the case, the possible legal issues in the case, the possible defenses you could try to raise at trial, and the possible outcomes of a trial with your attorney.
Yes, Your Honor.
And are you satisfied with his advice and competence in this matter?
Yes, Your Honor.
Are you under the influence of any types of drugs or alcohol at this time?
No, Your Honor.
Have any threats been made to get you to plead guilty?
No, Your Honor.
Now, before I go to the next question, I skipped over something that I didn't inform you. And that is that these two offenses are both felonies of the second degree, and because of that, and again, as I indicated, you will have to be sentenced to prison and serve a prison term. Now, once you complete that prison term, it's mandatory as part of the sentence that you be supervised by a parole officer on a term set by the Adult Parole Authority for a period of at least 18 months up to a maximum of 3 years once you get out. And if during that period of time that you're being supervised by the APA, they determine that you have failed to comply, they could return you to prison to serve an additional period for doing that, but for committing that violation, of up to 9 months for a single violation, but there is a cap or limit of half whatever prison term is imposed for all violations. But if you commit a new felony while under post-release control, then in addition to whatever sentence the judge can impose for that new case, that judge would also be authorized to sentence you for committing the new offense while under post-release control in these cases to an additional period of 1 year, whatever time is left on the period of post-release control, whichever is greater, which would have to be served consecutively to the sentence in the new case. Do you understand that?
Yes, Your Honor.
All right. Now, about halfway down page 2, there are several lines that are printed in bold and underlined, which are what I call the substantive terms of the plea agreement, and so I will read those into the record at this time. Defendant shall enter a plea of guilty to count 1, count 3, and count 7. State will dismiss remaining counts. State defense jointly recommend 2 years mandatory incarceration on count 1, consecutive 2 years mandatory incarceration on count 3. Defendant agrees to pay back fine money to Huntington County Task Force, the amount of $1,350 joint several with Sierra and Nicole Wilson. Agrees to forfeiture outlined in count 7. And agrees to cooperate fully in the prosecution of the co-defendant and cooperate fully with the task force. In count 7, there's no penalty for that as far as prison or fine, but it would result in the forfeiture. It alleges that on or about the 8th of August, you had a 2013 black Ford Focus that is subject to being forfeited because of its use in the commission or facilitation of the offense. So that penalty for that would be forfeiture of that vehicle to the government. You understand that?
Yes, Your Honor.
Right. Now, I just read you the terms of the plea agreement, the substantive terms. Has anyone promised you anything other than what I just read in out of this plea agreement to get you to plead guilty?
No, Your Honor.
Now, and you again understand that this calls for the minimum sentence of 2 years on each count, 4 years, which is the minimum mandatory sentence you would have to serve, and then it would be possible that could be extended by 50%, which in this case would be 1 year because 1 is half of 2. You can only do that on 1 count, so it means your sentence will be between 4 and a mandatory 4 and possibly up to 5 years, if I follow the agreement. You understand that?
Yes, Your Honor.
Well, under the law, Mr. Wilson, the judge is not bound by the recommendation of the parties in the plea agreement. So even though there's a recommendation that the minimum sentence on each case be imposed, each count, I should say, if you plead guilty, I'm not required to follow that recommendation. I could determine that there should be a sentence that's higher than that, up to 8 years in each count, if I thought that was the right thing to do under the law and the evidence. You understand that?
Yes, Your Honor.
Mr. Wilson, do you hold any license or certification from any state governmental agency that governs any occupation or profession?
No, Your Honor.
All right, now you have certain constitutional rights you must understand before I can accept your plea. First, you have the right to counsel, and you have retained Mr. Fox. Now, in the event that you were unable to continue to pay Mr. Fox to represent you, the court would appoint an attorney for you at no cost. And so the reason I bring that up is I want to make sure that you're not entering into the plea agreement because of any worry that you're not going to be able to afford to pay for an attorney to defend you. Is that a concern of any sort?
No, Your Honor.
All right, thank you. Right now, you have a right to have a jury trial on these 2 counts, or 3 counts, I should say, including the forfeiture, in which 12 people would be selected from a group of citizens that live in this county that are summoned for jury duty on your trial date. After those 12 are selected, their evidence would be presented, and they'd be instructed on the law. And then that jury would have to decide by unanimous verdict on each of the 3 counts whether the state proved your guilt. Now, if you didn't want to have a jury trial, but you did not want to plead guilty, you can waive in writing, which means to give up your right to have a jury trial, and then in that case, you could have what's called a court or bench trial, and that means that instead of a jury hearing the evidence, it would be the judge who would hear the evidence, the judge would apply the law, and the judge would decide whether or not the state proves your guilt on any of the 3 counts. Do you understand that?
Yes, Your Honor.
Now, under the Constitution, you have the right to confront the witnesses against you in open court and to cross-examine them through your attorney. So what that means is witnesses against you would have to come into court and testify in front of you and your attorney and anyone else who was present. After the prosecutor is done asking questions, your attorney would ask questions. That's called cross-examination. The purpose of that is to bring out evidence that helps your side of the case. Do you understand that?
Yes, Your Honor.
Under the Constitution, Mr. Wilson, you have the right to use the power of the court to compel or force witnesses to come to court to testify for you, just like the state. So if you have witnesses you're not certain are going to come in voluntarily, at your request, the court issues a court order called a subpoena. That forces those people to come to court to be available to testify if you want them to, even though they don't want to be here, which is the same way the state's witnesses are forced to come into court to testify against you. Do you understand that?
Yes, Your Honor.
Under the Constitution, Mr. Wilson, you have a privilege against self-incrimination, which means you cannot be forced to give evidence in this matter at any time, including trial. No one can ever make you testify. The prosecutor can't, the judge can't. It's your decision, and if you decide not to plead guilty, if you decide not to testify, the fact that you did not testify in the case cannot be used against you in any way by any person at any time, and in fact, no one's ever allowed to talk about it with one exception. If there is a jury trial and you don't testify, the judge instructs the jury that because that is your right, they cannot consider it for any purpose. Do you understand that?
Yes, Your Honor.
Right now, under the Constitution, you are presumed innocent of these charges until proven guilty by the state of Ohio on every essential element of each of the 3 counts. What that means is that the burden of proof isn't on you to try to prove that you're not guilty simply because you've been accused by being indicted by the grand jury. In fact, under the law, you're not required to even present any evidence in your own defense at trial. You may, but you're not required to. But whether you do or not, the burden of proof will remain upon the state to prove your guilt by proof beyond a reasonable doubt on every essential element of each of the 3 offenses, which is the highest burden of proof that's known under the law. Do you understand that?
Yes, Your Honor.
Right now, originally you entered a plea of not guilty to these counts as well as the other counts. Plea of not guilty denies the allegation in the indictment, denies you've committed any crime, and it exercises or invokes all the rights that I just described. Now, if you change your plea to these 3 counts, from not guilty to guilty, that is the complete opposite of the not guilty plea. The guilty plea would admit the allegations in each of those 3 counts, admit that they're a crime, that you committed that crime, and in count 7, forfeiture. And that plea waives or gives up all the rights that I've explained today, except your right to have an attorney. You always have a right to have an attorney no matter what your plea. Well, with that exception, your plea of guilty waives gives up your right to have a jury or court trial. It waives gives up your right to confront the witnesses against you and to cross-examine them through your attorney. It waives gives up your right to use the power of the court to compel or force witnesses to come into court to testify on your behalf, the same as the state. It waives gives up your privilege against self-incrimination, because if you say you're guilty, the state's not required to prove that you're guilty. It also waives gives up your privilege against, or I'm saying your presumption of innocence, because if you say you're guilty, then the state doesn't have to prove you're guilty. And it waives gives up your privilege against self-incrimination because you're the one who says you're guilty, so that's what's used to find you guilty. Plea of guilty waives or gives up your right to have to file an appeal on any alleged violations of your rights you think could have occurred up until this point in your case, and it subjects you to being sentenced immediately by the court. Do you understand? If you are sentenced to the maximum sentence or under other certain circumstances, you can file an appeal. Otherwise, you waive your right to file an appeal. But if you did feel you had a right of appeal, it would have to be filed within 30 days of your sentencing entry being filed. Do you understand all that?
Yes, Your Honor.
And Mr. Wilson, are you a U.S. citizen?
Yes, Your Honor.
And again, you're entering into this agreement that you electronically signed voluntarily and are, again, continuing today to fulfill that plea agreement. Is that correct?
Yes, Your Honor.
Do you have any questions at all then about the charges or the possible penalties?
No, Your Honor.
You understand them?
Yes, Your Honor.
You have any questions about the plea agreement?
No, Your Honor.
You understand it?
Yes, Your Honor.
Again, you understand that the court's not bound by the recommendation as to sentence.
Yes, Your Honor.
Now, you have any questions about the constitutional rights I've explained?
No, Your Honor.
You understand those?
Yes, Your Honor.
Any questions about the plea of guilty, what it means, what will happen if you enter that plea here today?
No, Your Honor.
You understand it?
Yes, Your Honor.
Now, I didn't say this earlier, so I'll say it now. Since you're not in the courtroom sitting next to your attorney, if you have if you have any questions you'd like to ask him or anything you'd like to talk to him about before we go any further, I can put the two of you into a breakout room and you can talk privately without anyone else seeing or hearing you. Do you need to talk to him about anything?
No, Your Honor.
Do you have any questions at all about anything that I've explained to you here this morning?
No, Your Honor.
Then, Mr. Wilson, is it your decision to withdraw your not guilty plea, plead guilty to the charge, count 1 and count 3, as well as the specification in count 7, as outlined in this plea agreement?
Yes, Your Honor.
All right, then as to count 1, which alleges that on or about August 12, 2021, in Highland County, Ohio, that you and Sierra Nicole Wilson did knowingly sell or offer to sell methamphetamine, a Schedule II controlled substance, an amount equal to or exceeding bulk amount but less than 5 times bulk amount in the vicinity of a school zone, in violation of Section 2925.03A1 of the Ohio Revised Code. They charge of aggravated trafficking methamphetamine in the vicinity of a school zone, carrying a mandatory sentence of at least 2 years up to 8 years as ordered by the judge. The possibility of whatever sentence imposed by the judge being extended by up to 1/2. A fine of $15,000, a mandatory fine of $7,500, and a possible license suspension of 6 months to 5 years. How do you plead?
Guilty.
As to count 3, which alleges on or about September 2, 2021, in Highland County, Ohio, you and Sierra Nicole Wilson did knowingly sell or offer to sell methamphetamine, a Schedule II controlled substance, an amount equal to or exceeding 5 times bulk amount but less than 50 times bulk amount, in violation of Section 2925.03A1. Also a charge of aggravated trafficking of methamphetamine, a second-degree felony, the same penalties described in count 1. How do you plead?
Guilty.
As to count 7, that alleges that on or about August 8, 2021, continuing through September 8, 2021, in Highland County, Ohio, that you and Sierra Nicole Wilson had in your possession a 2013 Black Focus, VIN number 1FADP3J20DL219047, subject to forfeiture due to its instrumentality and commission or facilitation of the offense as defined in Section 2941.14.17, which will result in the forfeiture of that vehicle to the government. How do you plead?
Guilty.
All right, the court finds that on this day in open court, the defendant was advised of all of his constitutional rights, made a knowing, intelligent, and voluntary waiver of the same pursuant to Criminal Rule 11. The plea is accepted and ordered filed. The defendant is found guilty of counts 1, 3, and 7. Counts 2, 4, 5, and 6 are dismissed. Now, I believe we talked yesterday about having a sentencing at a later date, so Mr. Wilson could have some time to get prepared. Is that correct, Mr. Fox?
It is, Your Honor.
All right. And I think we did the same thing yesterday with Ms. Wilson. I think, so we're not going to have a PSI in this case. The next sentencing date is November the 2nd at 9 a.m. You available then, Mr. Fox? Or any time that morning?
I can be available that morning, Your Honor.
All right. We'll set it then for November the 2nd at 9 a.m. Bond will be continued. You're still on probation on the other case, Mr. Wilson, so whatever you're required to do in that case, you still have to do. Once you're sentenced, the court then will put on an order that will toll that, and then whatever period is remaining, once you complete your sentence, will be reinstated. So just make sure you do whatever they tell you to do over there. The other thing I'll also tell you, not that I have any reason to believe this, but I tell everybody this, is that if you don't show up for sentencing, you violate your bond, and once you're located, I explained to you, I'm not bound by the sentencing recommendation, and obviously if somebody doesn't appear for sentencing and they get caught later, that's usually taken into consideration in the sentence and usually results in a more severe sentence. So just so that you're aware of that. It's not personal. I just make sure I tell everybody that. Okay?
Yes, Your Honor. Thank you.
All right. And we don't have you're not here to get an assignment notice, but just make sure you note it. It's 9 a.m. November the 2nd.
Yes, sir.
In the courthouse. Anything further, council?
No, Your Honor.
All right, thank you.
Thank you.
All right, we have two cases here involving the same defendant, State of Ohio versus Levi T. Krebs, 22 CR 99, 22 CR 149. This is a final pretrial being conducted by Zoom. Mr. Krebs, you're Levi Krebs appearing there from the jail?
Yes, Your Honor.
All right, appearing on behalf of the state is Special Prosecuting Attorney Chris Kinsler, appearing on behalf of the defendant's attorney Bruce Wallace. Mr. Wallace, you may not have had this happen before, but I require attorney's address for Zoom hearings the same.
I will grab my coat.
Don't worry about it. We'll let you get by this time.
I'll be right back.
Okay. Is a case involving 2 counts of assault of a peace officer. It's scheduled for trial on the 24th of October. Case number 22 CR 143 is a intimidation of attorney, victim, or witness in a criminal case, and it is set for trial on October 27. This is a final pretrial. Is discovery complete in the case from both sides?
On behalf of the state, yes, Your Honor.
Okay, Ms. Wallace.
On behalf of defense as well, Your Honor.
Right. We have no pretrial motions pending, correct?
No, Your Honor.
All right.
That's correct.
So, are we then going to go ahead and proceed to trial both of these cases, or what's the situation?
Your Honor, as of right now, that is our plan, and I know Mr. Kinsler, I had called for Mr. Kinsler yesterday. I just literally walked in the office, had time to listen. I know he had called me back this morning. I didn't have a chance to call him. There have been no plea discussions, and while Mr. Krebs is on here, because I will explain to him, I was out for 2 weeks with COVID. Last Wednesday was my first day back in the office. So I will tell Mr. Krebs I'll be out to give him the supplemental discovery that Mr. Kinsler had sent to me, and I'll be out Monday to see you at the jail to go over that, Levi. But I will talk after we get off here, hopefully sometime today with Mr. Kinsler, so that I can communicate whatever offers there may or may not be, or discussions there may or may not be, when I visit Mr. Krebs Monday at the jail.
All right. My normal policy is a 14-day prior to trial date, which would put that on the 10th, which would be like next Monday, which would be Tuesday. I'll be out of the office, though, next week. So I'll put the deadline as Monday, the 17th, for something happen. We will nonetheless have to go ahead and send out jury notices to get the juries.
I only plan on calling, I think I may have subpoenaed 6 witnesses, but I think I only plan on calling 4.
Okay.
The second case, I don't think either case is going to be a problem for the state to present its case in one day.
Okay. All right.
I would agree, Your Honor. I don't see a problem getting each of these done in one day.
All right. Anything else we need to discuss then, counsel?
Judge, I have
Go ahead.
Judge, jury instructions, what is the process? Do we submit jury instructions?
No. I'll write the instructions. I learned long ago not to trust attorneys to write instructions. So, all right.
Well, Judge, I would argue with you, but I just...
Yeah, I know. A lot of judges are lazy. They want the attorneys to do it for them. The only exception I make to that is in med mal or something that's extremely different, because a lot of those cases are different. So, but otherwise, I always write the instructions. So, okay.
That answers that question. Judge, jury questionnaires, what is the process for us to...
You'll have to get a hold of the bailiff. We have those available. The jury will be sent out probably Tuesday, since Monday's a holiday, and he'll have the list then, and he'll pull together the questionnaire. He'll have copies for both sides. You can pick them up, or be easier than mailing them, because if we mail them, it's pretty bulky, and you may not get them till a day or two before the trial, the way the mail is. So.
Okay.
All right. Anything further?
Judge, how do you present? We anticipate presenting some documents, photographs and maybe documents between these two trials. How do I go about presenting them there? If I have them on like a flash drive, can I use a TV or a monitor there?
We do have you'll need to bring your own laptop and a means to hook into our TV. We have a 80-inch screen TV that you can project that on. We also have an Elmo if you have any physical evidence that you want to project up on that as well.
Okay, perfect, Judge.
Just need to make arrangements with the bailiff, beforehand, and so we can get it set. We can't get that set up till we have jury selection complete, because we'll use the whole courtroom for jury. But then as soon as we get a jury during the lunch hour or morning break, then just have your laptop and everything ready to go, and he can wheel that in there. It's an older TV, but we have a converter that converts the USB cable to whatever it is that's in that TV. That TV's about 10 years old, actually. But, I'm old-fashioned. I don't throw anything away until it quits working. So, yeah.
Understood, Judge.
All right. Anything else?
No,
All right.
Your Honor.
Thank you.
Thank you.
All right, Deputy, we need Robert Hurley. All right, are you Robert Hurley?
Yes, sir.
Case number 22 CR 192, State of Ohio versus Robert E. Hurley. Mr. Hurley is appearing by Zoom from the jail. His attorney is Jacob Wagner, appearing from his office by Zoom, representing the state's prosecuting attorney Collins. The defendant was arraigned on a charge of assault on a peace officer, fourth-degree felony without counsel. So pursuant to Rule 46, we're conducting the bail review hearing within 2 business days. Mr. Hurley's bond was set at $5,000. All right, Mr. Wagner, would you like to address the issue?
Yes, sir, Your Honor. I did go out and meet with Mr. Hurley today, kind of go over some of the allegations. I did advise him that $5,000 is a very reasonable bond on a case like this, but he is asking for a reduction, Your Honor. In the alternative, I think the parties would agree that there's been maybe the heart of this or part of this case involved substance abuse, or there's a history of it, that should I guess I'm asking the court if I was able to obtain an in-bed or a bed availability for him for substance abuse, if the court would entertain an OR bond or a furlough at a later date, Your Honor.
Well, I don't know. Don't know anything about the case yet. There's been no discovery. I don't know anything about Mr. Hurley's past. I don't know what the state's position is. I'll always, if you file something, I'll certainly look at it.
Yes, sir.
So, maybe you can get your discovery fast-tracked and talk to the state. Maybe there can be, you find out whether that's something that might be likely or not. But at this point, I can't tell you. So.
Yes, sir. I understand that. Respect it.
All right. Ms. Collins, anything you'd like to say?
I agree that the bond of $5,000 is definitely not egregious in this case, especially since Mr. Hurley just was convicted of the same charge in this court this year and is currently on community control for assault on a peace officer. So $5,000 definitely is not egregious based on this, as well as his prior criminal history. Thank you.
All right. Well, for now, the bond will remain the same. And again, as I indicated, subject to new information being brought before the court, it will be considered what it is. Thank you.
Thanks, sir.
All right. Is that all there is? Junior?
Yes, Your Honor.
All right,
Recording in progress.
Case number 21 CR 132, State of Ohio versus James Clark Zamora Jr. Mr. Zamora is appearing from the jail by video, or by Zoom. The State's represented by Prosecuting Attorney Collins, appearing from her office. Appearing from his office is Defense Attorney Jacob Wagner. Defense charged with illegal conveyance and aggravated possession of fentanyl-related compound. We had a pretrial yesterday, I believe, and Mr. Wagner was able to go out and speak to Mr. Zamora, and we had him held pending a possible resolution of this case, which is now before the court. And Mr. Zamora have been provided with a plea of guilty form, which is indicates you're going to plead guilty to count 2. It's a 3-page form plus an entry. And I'll hold up the, well, first of all, Mr. Wagner, you and your client both agreeable to his appearing before the court by Zoom rather than in person?
We are, Your Honor. I went out today and spoke to him about it, told him we'd be by Zoom today.
All right, and you're all right with that, Mr. Zamora?
Yes, sir.
All right, thank you. All right, now, if any time you do need to talk to Mr. Wagner, since you're not sitting next to him in the courtroom, just tell me, and I can put the two of you into a breakout room where he can talk with you, and it'll be just you and him, and no one else will be able to see or hear you, okay?
Yes, sir.
All right. Now, Mr. Zamora, I'm going to hold up this plea form to you. On page 1 has your name and plea guilty, and says count 2. You see that right there?
Yes, sir.
All right, and you recognize that form?
Yes, sir.
All right, then on page 3, toward the last sentence of that page reads, I enter this plea voluntarily, and immediately below that there's a signature line with signature of defendant, and you write really small, but I believe that's James Zamora, and is that your signature there?
Yes, sir.
All right, and you just signed this document this morning?
Yes, sir.
Now, before you signed it, did you go over it with Mr. Wagner and have him explain everything to you and answer any questions?
Yes, sir.
And when you signed it, did you understand it's an agreement to plead guilty, which means there won't be a trial? The next step in your case will be a sentencing hearing?
Yes, sir.
And do you feel you had enough time to consider this matter before making this decision? I know you were only brought back from prison yesterday and been there, now for about 2 days. Have you had enough time to your satisfaction to be able to fully consider this matter before you make this decision?
Yes, Your Honor.
Are you entering into the agreement to plead guilty voluntarily?
Yes, sir.
All right. The agreement states on page 1 that you're going to withdraw your not guilty plea, plead guilty to count 2, aggravated possession of a fentanyl-related compound under 2925.11 of the Ohio Revised Code. That's a second-degree felony. Further states that you understand the maximum penalty for that could be imposed by the judge is 8 years of mandatory time. The minimum term the judge can impose is 2, and it goes every year from 2 to 8. Now, that's the minimum mandatory term. Whatever that number is imposed by the court, you will have to serve. However, this violation is subject to Reagan-Tokes law, which allows the Department of Corrections, Rehabilitation and Corrections, to extend a sentence imposed for this type of offense by up to 1/2 of the sentence that was imposed by the judge. So, using the worst-case scenario, 8 years, that could be extended by 4 years, which is half of 8, so it could mean that your maximum sentence could be 8 to 12 years. Your minimum sentence would be 2 years, and the DRC then could extend that if they chose to do so by 1 year. So that means your sentence would be 2 to 3 years. 2 years. The low number is mandatory, and then the 1/2 number is, again, it depends on the DRC. I can't tell you how they do that or why they do it, but they have that right. You understand that?
Yes, sir.
Yeah. You understand what I'm saying?
Yeah.
Okay. Now, you're serving a current prison term, and so any prison term that you might receive out of this case would likely be ordered to be served consecutively, meaning after the sentence you are currently serving. Do you understand that?
Yes, sir.
Now, other than the sentence you're currently serving and this charge, are you facing any felony charges anywhere else?
No, Your Honor.
Right. And you're not on a probation, parole, community control, or post-release control from any jurisdiction at this time?
No, sir.
All right. Now, under the law, once you serve the mandatory prison term imposed by the court and any additional time up to 1 more year that the DRC might offer if it's a 2-year, or 4 years if it's an 8-year, or any whatever happens in between. But whatever prison term that you would be ordered to serve, because it is mandatory, once you complete that term and any additional term the DRC might require and are released from the institution, It is mandatory that you be under post-release control supervision for a period of at least 18 months up to a maximum of 3 years. That means you'll be supervised by a parole officer on the terms that the APA sets because the court has no involvement with that. And if they determine while you're under supervision that you have failed to comply with those conditions, then they can return you to prison to make you serve an additional period of up to 9 months for a single violation, up to a maximum of half of your prison term for all violations. However, if you commit a new felony, then in addition to whatever sentence the judge could impose on the new case, the judge would also be authorized to sentence you to an additional period for committing that offense while under post-release control in this case, 1 year, whatever time would be left on the period of post-release control, whichever is more or greater. If that occurs, that has to be served consecutively to the sentence in the new case. Do you understand that?
Yes, Your Honor.
And again, this case is one in which community control, judicial release, early releases, none of that is possible. Do you understand that?
Yes, Your Honor.
All right, now, the charge in count 2 alleges that on or about March 4, 2021 in this county, you did knowingly obtain, possess, or use a Schedule II controlled substance, to wit, a fentanyl-related compound in an amount equal to or exceeding 10 grams or less than 20 grams in violation of Section 2925.11. So that's the charge of aggravated possession of fentanyl-related compound, second-degree felony with the possible sentences that I've explained. Now, Mr. Moore, do you understand what it is you're charged with, what the state said you did, when, where, and how they led you did it?
Yes, Your Honor.
And have you discussed the nature of the charge, the evidence in the case, possible legal issues in the case, the possible defenses you might try to raise at trial, the possible outcomes of a trial with your attorney?
Yes, sir.
Are you satisfied with his advice and confidence in this matter?
Yes, sir.
Are you under the influence of any types of drugs or alcohol at this time?
No, sir.
Has anyone threatened you to make you plead guilty here today?
No, sir.
Now, on page 2, there are 2.5 lines that are printed in bold and underlined that read as follows. Defendant shall enter a plea of guilty to count 2. State will dismiss count 1. State and defense jointly recommend 2 years mandatory incarceration consecutive to the term of incarceration defendant is currently serving. Is that your understanding of the agreement?
Yes, Your Honor.
And again, you understand that the 2 is a minimum and it could be extended up to 3, depending on what the DRC does.
Yes, Your Honor.
Now, Mr. Zamora, under the law, the matter of sentence is up to the judge, not the parties. And so even though there's an agreed recommendation, I'm not required to follow that. If you are convicted of this offense, I could sentence you to that, or if I thought that was not the right sentence under the law and the evidence, then I could sentence you to as much as 8 years. You understand that?
Yes, Your Honor.
Do you hold any license or certification from any state and governmental agency that regulates any occupation or profession?
No, sir.
Right now, you have certain rights you must understand before I can accept a plea of guilty from you. First, you have a right to have counsel. Mr. Wagner was appointed not simply to work the case out, but provide any defense that can be available to you under the law that you would like him to provide. So, if you don't want to do this, you want to defend the charge and go to trial, he'll represent you if that's what you decide to do. You understand that?
Yes, sir.
Right now, under the Constitution, Mr. Zamora, you have a right to have a jury trial on this charge, in which 12 people would be selected from a group of citizens that live in Highland County that are summoned for jury duty on your trial day. After 12 jurors are selected, the evidence is presented, they're instructed on the law, and then they decide by unanimous verdict, meaning all 12 of them have to agree on the verdict as to the charge, as to whether the state proved your guilt. Now, if you didn't want to have a jury trial, because you didn't want to plead guilty, you can waive in writing, which means to give up your right to have a jury trial, and in that case, you would have what's called a court or bench trial, meaning it's the judge who hears the evidence, applies the law, and decides whether the state proved your guilt instead of a jury. You understand that?
Yes, sir.
Right now, under the Constitution, Mr. Zamora, you have a right to confront witnesses against you in open court and to cross-examine them through your attorney. What that means is witnesses against you have to come into the courtroom and testify in front of you and your attorney and anyone else that may be present. After the prosecutor's done asking those witnesses questions, your attorney has the right to ask questions. That's called cross-examination. And the purpose of that is to bring out evidence that helps your side of the case. Do you understand that?
Yes, Your Honor.
Right now, under the Constitution, you have a right to use the power of the court to compel or force witnesses to come into court to testify for you, the same as the state. So, if you're not certain that witnesses you think you have are willing to come into court or can come into court voluntarily, at your request, the court issues a subpoena, which is a court order, and that forces those people to come into court to testify at your trial if you want them to, even though they don't want to be here, which is the same way the state's witnesses are forced to come into court to testify against you. You understand that?
Yes, sir.
All right, Mr. Zamora, under the Constitution and the law of this state, you have a privilege against self-incrimination, which means you cannot be forced to give evidence in this matter at any time, including trial. No one can ever make you testify. The prosecutor can't, the judge can't. It's your decision. If you decide not to testify, the fact that you did not testify cannot be used against you in any way by any person, and no one's even allowed to comment about it, except in one situation, that is if there's a jury trial and you don't testify. The judge instructs the jury that because that is your right, they cannot consider it for any purpose. Do you understand that?
Yes, sir.
Now, Mrs. Zamora, under the Constitution, you have a presumption of innocence, which means you're presumed innocent until proven guilty by the state of Ohio on every essential element of the offense charged. So there's no burden on you to try to prove you're not guilty simply because you've been accused by being indicted. In fact, under the law, you're not required to present any evidence in your own defense. You may, but you're not required to. But whether you do or not, the burden of proof will remain upon the state of Ohio to prove your guilt by proof beyond reasonable doubt on every essential element of the offense charged, which is the highest burden of proof that's known under the law. You understand that?
Yes, sir.
Right now, originally you entered a plea of not guilty. That plea denied the allegations in the indictment, denied you committed any crime, and it exercised or invoked all the rights I've just described. Now, if you change your plea today from not guilty to guilty to count 2, that is a complete opposite of the not guilty plea. The guilty plea admits the allegations in count 2, admits that they're a crime, that you committed that crime, and that plea waives or gives up all of the rights that I have just described for you today, except your right to have an attorney. You always have a right to have an attorney no matter what your plea. But with that exception, your plea of guilty waives or gives up your right to a jury or court trial. Waives or gives up your right to confront witnesses against you and to cross-examine through your attorney. Waives or gives up your right to use the power of the court to compel or force witnesses being in court to testify for you, the same as the state. Waives or gives up your privilege against self-incrimination because if you say you're guilty, that's what usually defines you guilty. Waives or gives up your presumption of innocence because if you say you're guilty, the state's not required to prove you're guilty. It also subjects you to being sentenced immediately by the court. And finally, it waives or gives up any right to file an appeal that you think you may have had up until this point in the case. Now, if I should sentence you to the maximum sentence, or under other certain circumstances, you could file an appeal. That would have to be filed within 30 days of your sentencing entry being filed. Do you understand all of that?
Yes, sir.
And are you a U.S. citizen?
Yes, Your Honor.
All right. Now, do you have any questions about the charge or the possible penalties?
No, Your Honor.
You understand them?
Yes, sir.
Have any questions about the plea agreement?
No, Your
You
Honor.
understand it?
Yes, sir.
Have any questions about the constitutional rights I've explained?
No, Your Honor.
You understand that?
Yes, sir.
You have any questions about the plea of guilty, what it means, and what will happen if you enter that plea here today?
No, sir.
You understand it?
Yes, sir.
Is there anything you need to speak with your attorney about before we go any further?
No, Your Honor.
You have any questions about anything I've explained to you today?
No, sir.
Then is it your decision to withdraw your not guilty plea and plead guilty to the charge, according in count 2, according to the terms of the plea agreement that I've just gone over?
Yes, sir.
And as to the charge, which alleges that on or about March 4, 2021, Highland County, Ohio, you did knowingly obtain, possess, or use a Schedule II controlled substance, to wit, a fentanyl-related compound, amount equal to or exceeding 10 grams or less than 20 grams, in violation of Section 2925.11 Ohio Revised Code, a second-degree felony carrying a mandatory prison term of at least 2 years up to 8 years set by the judge, possibility of an additional 1/2 of whatever sentence imposed by the judge being added by the DRC, a fine of $15,000, and a possible license suspension of 6 months to 5 years, and a mandatory fine of $7,500. How do you plead?
Guilty.
All right, the court finds on this date, open court, defendants advised of all his constitutional rights, and made no intelligent voluntary waiver of the same pursuant to criminal rule 11. Please accept that order filed. Defense found guilty of count 2 as charged. Count 1 is dismissed. Court will not order a pre-sentence investigation, and we will go ahead and proceed with sentencing forthwith. Anything from the state?
No, Your Honor, we would ask the court to follow the joint recommendation. Note that Mr. Zamora is currently serving a sentence out of Ross County, and we would ask that the sentence be ordered served consecutive.
Would you talk to Marcia about the Cobb case? And, okay, next week. Okay, well, then you make sure they call the attorney and her to let them know that the hearing's on. Because it's set at 2:30, I don't want to drive down here for nothing. All right, Mr. Weiger, anything on behalf of the defendant?
Your Honor, we would just ask the court to follow the recommendation. And he is obviously serving a sentence out of Ross County. But again, this was a case where my client was brought back late yesterday, met with him today. There wasn't too much debate with him. He acknowledged the, not allegations, but acknowledged the facts as outlined in the indictment. He knows full well it would be consecutive. He didn't even ask for it to be concurrent. He knows what's ahead of him, Your Honor. We ask the court to follow the recommendation.
All right, Mr. Zamora, anything you would like to say?
No, Your Honor.
All right. Well, the record clear that you have cooperated with this and taken responsibility. And so based upon that, the court is going to follow the recommendation in the plea agreement. So it's an order judgment of the court that you be and are hereby sentenced to a mandatory term of 2 years as a minimum, with the possibility of it being extended to up to 3 years by the DRC under the Reagan-Tokes law. You'll be given credit for 2 days of jail time, which will be yesterday and today while you're here. And then I imagine they'll take you back tomorrow, resume your sentence in the other case. Now, upon completion of this term, the Adult Parole Authority is required to put you under post-release control supervision for a period of at least 18 months up to a maximum of 3 years. And if during that period of time they determine that you have failed to comply, they can return you to prison to make you serve an additional period of up to 9 months for any one violation, up to a maximum of 1/2 of your prison term that you serve for all violations. However, if you commit a new felony, in addition to whatever sentence a judge in the new case could impose upon you, that judge could also sentence you for committing that crime while under post-release control, in this case to an additional period of 1 year or whatever time is left on that post-release control, whichever is more. And if that occurs, that would have to be served consecutively to the sentence in this new case. You're also ordered to pay the court costs, which judgment, grant, and execution is ordered. And if you don't pay those, then upon completion of your prison term, not while you're in prison, but once you get out, you could do community service in this county and be given credit for each hour you work in an hourly rate set by the court. And each hour you work will reduce your judgment by that amount until paid in full. Given that you're incarcerated, you'll be serving a 2-year minimum mandatory sentence. The court will find that because of your indigency, you're not able to pay the fine that's mandatory, so the court will waive that. All right, is there anything further from counsel?
No, sir.
All right.
No.
Thank you. All right, we're going to leave this session open, Ms. All right, are you Donald R. Collins?
Yes, sir.
All right, this case number 22, CR 92, State of Ohio versus Donald R. Collins. President, on behalf of the state's prosecuting attorney Collins, this hearing is being conducted by Zoom, she's appearing from her office. Representing the defendant is attorney Jacob Wagner, appearing from his office, and the defendant's appearing by Zoom from the jail. And Mr. Collins was placed on community control on August the 17th for 2022 for the offense of aggravated trafficking of methamphetamine, a third-degree felony. The probation department alleged on September 27th that the defendant had failed to comply with the conditions of community control in that he was failed to complete the STAR program as directed. The court notified Mr. Collins of that allegation, appointed Mr. Wagner to represent him, and the matter set for evidentiary hearing. The records show Mr. Balser is present in the courtroom from the probation department. Now, Mr. Wagner, are you and your client agreeable to this hearing being conducted by Zoom rather than in-person appearance?
We are, sir. We spoke about it this morning.
You're all right with that, Mr. Collins?
Yes, sir.
All right. Have you had an opportunity to consult with Mr. Collins about the charges and whether there will be a hearing or not?
we would stipulate or agree to the violation of not completing the STAR program as ordered, Your Honor.
All right. And Mr. Collins, your offense is a third-degree felony, which carries a possible prison term of between 9 and 36 months in certain levels in the statute. It goes from 9 to 12, and then every 6 months up to 36 months. There's also a possible fine of $10,000. Now, if you are found to have violated the conditions of your community control, whether that's by a hearing where evidence is presented or by your own admission, one of three things can happen. I can continue your community control under the same conditions. I can continue with additional conditions I think are more that need to be added. And the third and most serious, I can revoke your community control and then sentence you to prison for between 9 and 36 months and fine you the $10,000. You understand that?
Yes, sir.
And you do have a right to have a hearing in this matter in which the state would have to present evidence and testimony from witnesses as to whether you complied with the condition. You would have a right to have your attorney ask those people questions. That's called cross-examination. You're entitled to present evidence on your own behalf, although you're not required to do so. Do you understand that?
Yes, sir.
Has anyone promised you anything or threatened you in any way to get you to admit to the violations?
No, sir.
All right. Do you have any questions at all about the procedure or the allegations?
No, sir.
All right. Then did you admit the allegation that you failed to complete the STAR program as required?
Yes, sir.
All right. All right. Anything from the state probation department regarding disposition?
I'm not sure what the probation department is requesting from us.
He self-terminated from the STAR program.
Okay. I know what the court is inclined to do in that case, so I would just say that Mr. Collins has been helpful to the task force.
All right. Mr. Wagner?
Your Honor, again, playing off Ms. Collins's lead, I spoke to Donald today and told him in my experience, not to take the court's thunder away, but typically anyone that does not complete STAR, about a 99% chance of where I can tell they will go. We did discuss what's going on in his life. He indicated a desire to go to try another rehab facility. I again echoed, this court will tell him you don't get to pick your rehab facility. And he acknowledged that. Again, I asked him what was wrong with STAR. I'm not saying it's justified. I guess you should have completed it. He indicated that it's a younger dynamic down there, younger kids, adults. He didn't fit in, wasn't receiving what he could have or benefit from that. Stealing from whatever he had. It just wasn't a good fit. I mean, maybe he should have turned the other cheek and made it a good fit because the alternative is prison. But he did not balk at me 1 ounce. He brought it up actually. I'm willing to do any kind of drug rehab to address the issue, whereas STAR, from my understanding, is more behavior modification. Maybe he needs to get his behavior modified to get along with people. I don't know. But he's not opposed if the court would accept or maybe look at him as Kent's place or Ed's place. But otherwise, Your Honor, Donald also acknowledged he'll do his time. He didn't cry and whine about that. So I guess we're at the mercy of the court, Your Honor.
All right, Mr. Collins, anything you would like to say? Oh, I did unmute myself. Mr. Collins, anything you would like to say?
I just couldn't get along down there.
All right, well, Mr. Collins, the order was, I think, quite clear, and you were charged with some really serious offenses that were mandatory time, first and second degree felonies, and, you were given a break by the state along with a recommendation for community control, and the court determined that you should complete the STAR program, and I'm sure I told you, I tell everyone, you complete it 100%. And, The problem that you have isn't that you don't fit in, is that, you don't want to do what it takes to get your life changed. The problem is attitude, it's not location. And so you failed to comply with the court's order, and I'm just a little disappointed, Mr. Wagner, because I thought my record was 100%, with the exception of people that have medical emergencies that have to leave. But in any event, it's the order and judgment of the court that you have failed to comply with community control, that you're not amenable to community control, and therefore your community control is revoked, and it's ordered that you be sentenced to the Correction Reception Center at Orient, Ohio, for a period of 18 months. According to the sheriff, you have 53 days credit on your sentence, and let's see, you went to Star, I think, you go on the first, Mr. Bolser?
I believe it was August 31st.
August 31st to
9/26.
9/26, so that would be an additional 27 days. So that would be a total of 80 days. Now, upon completion of this sentence, Mr. Collins, it is possible the adult parole authority will place you under post-release control for a period of up to 2 years. They don't have to, but it'll be up to them. If they do, you'll be supervised on the terms they set, and if during that period of time they find that you have failed to comply, they can return you to prison to make you serve an additional period of up to, in this case, 9 months for one or more violations. That's the cap. However, if you're convicted of a new felony, then in addition to whatever sentence a judge in a new case could have imposed upon you, that judge is also authorized to sentence you for committing that offense in this case, while under supervision in this case, to an additional period of 1 year, or whatever time is left on that period of post-release control, whichever is greater. If that occurs, that must be served consecutively to the sentence in a new case. You're also ordered to pay the court costs from the judgment, grant, and execution's order. If you fail to do that, then the clerk can collect that through various means, including levying on bank accounts, wages, earnings, or other assets you may have. If that doesn't get it done, then upon completion of your prison term, not while you're in prison, you can do community service in this county and be given credit for each hour you work and an hourly rate set by the court. Each hour you work will reduce your judgment by that amount until paid in full. All right, is there anything further from counsel?
Judge, can you put Mr. Wagner, Mr. Collins, and I in a breakout room just for a moment?
Sure.
Let me do it.
Catherine, we have Haynes down as a Zoom hearing.
It sent me the invitation. He may have hit the wrong name. I denied it. Oh, there they go.
Case number 20 CR 236, State of Ohio.
Recording
versus,
stopped.
Ivan McClure, present for the state, as Assistant Prosecuting Attorney King. Mr. Balser for the Probation Department. Present for the defendant is Attorney Dennis Kirk. And you are Ivan McClure?
Yes, Your Honor.
All right. This is a matter set for an evidentiary hearing. The defendant was placed on community control on May 21st, 2021 for, I believe, gross sexual imposition. The probation department filed a notification on September the 6th alleging that he had failed to comply with Rule 8, and that he, on or about August 17, 2022, consumed alcoholic beverage, and in Rule 13, on September 5, he left the Phoenix Center against staff orders. Court advised Mr. McClure of that on September the 6th, and appointed Mr. Kirk to represent him. The matter is now set for hearing. All right. Is there, okay, first of all, you had a chance, Mr. Kirk, to review the allegations with your client?
I did, Your Honor. He did come, excuse me, he did come in and meet with me.
You need Katrina Haynes next?
Just mute that. We'll need Ms. Haynes in about 2 minutes. I'm doing another hearing right now, but yeah, she'll be next, and we'll get her in about 2 minutes.
I think your mic's off.
Oh. Yeah, well, Ms. Haynes will be next.
Okay. Sorry. Yeah.
All right.
We did go over it, and I did advise him of his right to a hearing. He does wish to waive the hearing and admit to the violations.
All right, Mr. McClure, you have a right to have a hearing on these allegations in which the state will have to present evidence that proves to court satisfaction you've failed to comply. You do have a right to present evidence on your own behalf, although you're not required to. If the court finds that you have failed to comply, one of three things can happen. I can continue your community control under the same conditions that I ordered originally. I could add conditions to your community control that I think are appropriate. Or the third, and most serious, revoke your community control and sentence you to prison for anywhere from 6 to 18 months and fine you $5,000. Now, you understand the allegations against you?
Yes, Your Honor.
And you understand the possible consequences if you admit or are found to have violated this by evidentiary hearing?
Yeah, yes, Your Honor.
And you have any questions about the allegations or the process or the procedures?
No, sir.
And has anyone threatened you or promised you anything to get you to do this?
No, sir.
All right, are you entering into, so you've agreed to this voluntarily?
Yeah, I drank and all that.
All right, so you admit to the allegations then that were filed against you on September 6th, all right. All right, anything from the state regarding disposition?
Thank you, Your Honor. This is the defendant's first community control violation. He has not yet been to the STAR program, so with that being said, State and Probation Department would just ask that he be continued on community control in order to complete STAR, and there's a bed available at STAR on October 19th. Thank you.
Mr. Kirk?
Thank you, Your Honor. My client did admit and own up to the allegations. In the meantime, he has been attending Friel, so he did at least recognize the need to continue in some form of treatment. So he did leave the Phoenix Center, and he's been at Friel. He did make contact with the Phoenix Center. They advised they would accept him back, and he could have a bed as early as the 10th of October. I've talked to him about STAR. He's obviously open to that option as well, recognizes the need for additional help. He does have a baby on the way, and I believe they are going to induce the mother this evening at Clinton Memorial, so yeah, would ask for the chance of community control to continue with any type of treatment available. He did participate, I believe, in the Vivitrol program as well, so he's showing some signs of attempting here. I know he's not done everything the court wants, but it would ask the court to give consideration for what he has done and continue him on community control with any additional treatment or STAR as the court sees fit.
All right, Mr. McClure, anything you would like to say?
I'm just sorry for being here.
Well, Mr. McClure, I normally don't give people convicted of sex offenses community control. So you've already gotten a chance that 99% of the sex offenders that appear before me do not get. And in fairly short order, you have managed to blow that up. So what I want to let you know is this. My patience is the issue. It's my belief that people that commit sex offenses are probably dangerous because most people don't commit one single sex offense. Maybe you are the exception, I don't know. But I just want to let you know, I'm going to give you one more chance. And I'm writing on the bottom of this page right now in big letters so I can see it when I pull the file open. If this happens again, if you come back in front of me, last chance. So I'm going to continue your community control. With these conditions, you're going to be required to complete the STAR program. I'm not going to let you go back to where you came from because we already tried that and you walked away. You just didn't take it seriously because apparently you think that the judge doesn't mean what he says, but the judge does mean what he says. So you're going to successfully complete that STAR program. And as you just saw, we had a guy that didn't successfully complete it. If you don't complete it and you come back here, you're going to go to prison. You know, period, end of story. Unless you have a heart attack or something and they have to take you out because you're in the hospital. But short of that, you know, you have to complete it. And you have to comply with the other conditions too. And I mean that. And there's not going to be, you know, any further chances if you come back before the court and you have been found to have violated your community control, that will be it. So you're required to complete the STAR program and aftercare, and you are to report to the jail on October the 16th at 1 p.m. for the bed date on October 19th. It's required you have 3 days of no opportunity to use drugs before you go in. All right, you're going to get an assignment notice here from the bailiff, and hopefully things will go all right with your baby. But don't be coming back asking for a delay because your problem, is you need to get yourself straightened out, and you're not letting value to your family right now in the condition you're in. And until you decide to change, you're not going to be any value to them in the future. And so, you need to understand the 16th, you're to be there. Period. End of story.
Yes,
Do you have any questions?
The only reason I left there is just because I had to pay bills.
I don't care why you left there, because I told you to finish it and you didn't do it. So the only thing I care about is, did you do what I told you? And the answer is no. I don't care why you didn't do it. It doesn't matter. You don't make the decisions. The reason you don't get to make those decisions is because you've done a real crappy job of your own decision making in the last few years. So now other people have to make your decisions for you. And I did that, and you ignored me. And you won't do it again. Because if you do, well, let me back up. Maybe you will do it again, because chances are pretty good that you will. But if you do, you're going to pay the price. That's going to be the situation. So that's what you need to know. All right? So you see go report down to the probation. Well, Mr. Balzer will tell you what to do. All right? And you're going to get an assignment notice from the bailiff that tells you to report on October the 16th to jail at 1 p.m. without fail. All right. Thank you.
Thank you.
All right. Mr. King, we had to continue that Cobb case. Apparently when I gave the file to Marcia, I didn't get the word to her that I couldn't hear the case. I think I told the bailiff, and I think it didn't get communicated to her, that Ms. Cobb has done a lot of work for me. Her company that she owns does a lot of work for me at home. And in fact, just last month, they power washed my deck and painted my fence, so I can't hear that case. I don't think it would be, even if it was waived, I don't think it would look good. So I think we're going to get Judge Crawford to hear it.
Okay, does that just leave us with Pitzer at 2:30 then as far as the in-person?
Yeah. All right, you're Katrina Haynes appearing there from the jail?
Yes.
All right, we have 3 cases involving this defendant. 14 CR 125. 14 CR 206. 20 CR 92. Defendant was granted community control originally in 14 cases, and then later was admitted into drug court after the 20 case. And there has been a notification filed. She has completed the drug court curriculum, but was retained on community control because she had not yet made all of her financial obligations. And then there was been a violation filed by Officer Carr that was filed on September 21. Alleging that she had violated Rule 2, failing to report. Rule 7, refused to take a drug screen. Rule 13, failed to complete an assessment for counseling. And Rule 15 is failed to make payments. All right. The court notified Ms. Haynes of the allegations and appointed Ms. Hapner to represent her. And have you had an opportunity to talk with her, Ms. Hapner?
I have.
All right. And you and she are both in agreement this matter can be conducted remotely rather than in person?
Yes.
I can't hear you.
Yes.
All right. Let's see if my volume's down or if it's yours. Yeah, you may need to get a little closer to your microphone. So, okay. And you're all right with that, Ms. Haynes?
Yes.
All right. Now, does your client wish to have a hearing, or will she be making any admissions?
She does not deny the allegations, but we'd like to make a statement in mitigation.
Sure. Okay. All right. So my understanding, Ms. Haynes, then, is that you're not going to contest the allegations. You admit that they're as alleged. Obviously, it doesn't mean we know what's going to happen. You can make any kind of statement as well as your attorney in terms of, mitigating or, whatever the sanction ought to be. But you understand the violations?
Yes, sir.
And in the event that you're found to have violated, I can do one of three things. I can continue community control under the same conditions previously ordered. I can continue it with additional conditions I think are appropriate. Or the third, the most serious, is I can revoke your community control and sentence you to prison in 20 CR 92. It's a aggravated possession of methamphetamine, a fifth-degree felony. So that's a possible 6 to 12 months in prison. In 14 CR 206, it's burglary, which is a second-degree felony, which would be 2 to 8 years. And the 14 CR 125 case, I'll have to find out what that is. I forget now. And actually, that was a judicial release, so it was already a sentence in that case, and she was judicially released. I've forgotten that. So whatever time is left on the original sentence that you received would be what was would have to be served. And
I already went to prison on all three of the cases besides the 2021.
yeah, I understand that. I'm just looking here. I'm just telling you what the possible sentence is. And in that case, the conviction was for aggravated trafficking in meth and vicinity of juvenile, a third-degree felony, and aggravated possession of meth, a fifth-degree felony. So that's a 6 to 12 month on that charge, and then the other count is well. Anyway, I already sentenced you, so I don't know what whatever time you had left on that charge would be subject to being served. So you understand the possible consequences if you admit to these violations or you're found to have committed them after a hearing.
Yes, sir.
And has anyone promised you anything or threatened you in any way to get you to admit to these allegations?
No.
All right. Then do you admit the allegations that were filed by the probation department?
Yes.
Okay. All right. Do we have anything from the state or the defense, or from the state or the probation department, I should say?
Your Honor, the state contacted the probation department today, and for whatever reason, they're taking no position on the sentencing in this case. The state has a strong position that Ms. Haynes should be ordered to serve the remainder of any prison sentence in all of her cases. She has been given multiple opportunities, more than about any defendant I can remember seeing in the court system. She's violated, been continued. was given judicial release, been continued on probation, violated, put into drug court, violated, continued. Her violations at this time include not reporting on a couple of different occasions, refusing to take drug screens. She's not compliant with treatment recommendations. Can I ask, because there's no mention of this in our file, did she successfully complete drug court?
She completed and graduated, yes, but she was retained solely because she had not paid her financials.
Well, and then Tuesday, just this past Tuesday, she was bound over, waived her preliminary hearing on a new burglary charge. So based on that, frankly, I'm a little shocked the probation office didn't want to take a position, because I haven't seen somebody given this many chances where they haven't wanted to take a position. Our position is she's been given plenty of opportunity, has not availed herself of any of those opportunities, and should be sentenced to a term of incarceration.
All right, Ms. Hapner?
Thank you, Your Honor. The only reason she was retained on probation was to pay her fines and costs. And we understand that that has not been done, but she did successfully complete drug court and she did graduate from there. And it was, and I may be mistaken about this, but my understanding had been that if drug court is completed, that typically people are done. You know, they're no longer on probation. As I say, that was my understanding, and that may be an inaccurate understanding. But she was only retained for financial reasons, not necessarily for supervision reasons. Mrs. Collins is correct that she did waive her preliminary hearing on Tuesday. My request is that she simply be terminated as an unsuccessful probation, if you might want to address it that way. Close out these 3 cases, 2 of which are from 8 years ago, and then let's address whatever we need to address in the new case.
All right. Ms. Haynes, anything you would like to say?
No, Your Honor.
Well, Ms. Haynes, everything that both of the attorneys said is accurate. You know, and you've been given a lot of chances because you're in drug court, and you know, you did fairly well. Well, you did well enough you graduated, and had you made your payments on court costs, you would have been off. And in fact, we had actually considered administratively terminating you and transferring you to the regular docket in order to do that. And then what happened is you started relapsing, and I think primarily because of your mental health. And that's going to be an ongoing issue for you for the rest of your life. And in all honesty, I think you would acknowledge that that's one of the things that you struggled with a little bit during the program. You were not fully engaged, or I think open enough with yourself to admit what you had to do. You may not be there yet. I don't know. And so that's the problem that has happened. And now you've got yourself in more trouble. But, you know, what I'm going to do is this. I'm going to, because if you had paid your fines, you would have been off community control, and you would have been totally discharged. And under the Supreme Court decisions that we've had in the last few years, as well as a directive from the Supreme Court of Ohio about utilizing criminal laws to enforce collection of court costs or fines. I don't fine anybody in these cases. You know, I think that revoking your community control and sentencing you to prison on the 2 cases and plus the rest of your case would be problematic. So the court is going to terminate you from community control unsuccessfully and close your cases. You still owe the court cost. The clerk will still be able to chase you with levying on property and turning it over to the collection agency, and they will chase you for the rest of your life. So you're not getting out of paying the court cost. But at this point, I just don't feel comfortable under the law with sending you to prison for what essentially you should have been off. Now, what your behavior does show us, though, however, is that, you still have issues, and you're still gonna have to deal with that burglary case, so I guess if you're being held in jail on that, you're gonna still stay in jail. And so you're not out of the woods yet. That's something you'll have to, deal with, once we see if the grand jury indicts you or not. But if they do, then we'll see what happens. All right, is there anything further from council?
Your Honor.
All right, thank you. I think that's the last Zoom hearing. Okay, good. All right, case number 22CB072, Duncan Ridge Cemetery Association and Elmville Church of Christ Christian Union versus German Baptist Church, Duncan Ridge Cemetery, and unknown successors, trustees, and signs of both of those organizations. Appearing on behalf of the plaintiff is Attorney Catherine Hapner. This is a complaint to quiet title, and let's see, looking here, order of publication was made on June the 1st. Okay, Ms. Hammer, I don't have proof of service. I have the notice that it was to run June the 7th every week until July the 12th. Do you have a return of service, or do you have proof of service from the newspaper?
I believe it. I have seen it. I thought I had a file marked copy, but possibly not. No, but I've got about 2 dozen plats.
Okay. Well, sometimes they get put in the wrong case. They might,
Yeah.
usually those are for foreclosures. But yeah, if you can provide me with that, that should take care of that. And if you can't find a copy, there, the paper, I'm sure, can give you a duplicate copy. But it did run, I take it. You did see it run?
It did run.
Okay.
And I am fairly certain I've seen the publisher's affidavit, although I've had a couple cases on publication at the same time, and so,
Okay.
yeah.
All right. And do you have an entry with the legals and so forth prepared?
Not at the moment.
Okay. Have you had the descriptions checked?
I have, yes.
Are they going to be acceptable for transfer?
They are, we do have new surveys, and so they...
Oh, you do have new surveys?
Yes.
All right.
Yep, so they're going to accept those.
No,
Well, I think, I do have legal descriptions, yes.
All right. Those aren't in, did you get those after you filed, or are those included in this case, the new surveys?
They're not.
Okay.
Wallingford did those, and I do have those surveys.
All right.
So if you'd like to see those, I've got
Well,
them, or attach them to the
Yeah,
entry.
you'll need to attach them. So, okay, well, pending the filing of proof of legal publication service as required by the rule, court will grant the complaint and order title quieted in the plaintiffs as requested. And if you would, put in the entry that this is a new legal description, and it'll have to be either incorporated into the entry or attached as an exhibit, however you want to handle it. And then that should also, the order will need to include orders to the tax map office and the auditor to transfer, and the recorder to record a copy, a certified copy of the entry as proof of the transfer at the recorder's office, and then a copy of it to be used to transfer it on the tax records.
Sure.
Anything further?
No, we were prepared to give you a lesson, a walk down history lane.
Yeah. No, I read it. Interesting. There's a lot of these situations around. You know, I've dealt with a number of them over the years. There's a lot of churches around the county that have had to be closed. I dealt with several of the Methodist churches over the years. So, all right. Well, thank you all. First.
So we
All right, this is case number 19 CR 028, State of Ohio versus Paula J. Pitzer. Appearing on behalf of the state is Assistant Prosecutor King, and you are Paula J. Pitzer.
Yes, sir.
All right, Ms. Pitzer was convicted of possession of marijuana, I believe in June of 2019, and was successfully completed community control, was discharged early on December 16, 2020. She has filed an application to seal the record. I have looked at this, Ms. Pitzer, and unfortunately, and I'll ask Mr. King his opinion, but because your conviction is a third-degree felony, and the law as it, and I believe it's still in effect, it went into effect in April of last year, I don't think there's many changes since then, has there, Mr. King?
That's correct, Your Honor.
Right. Well, when that law went into effect, for a person convicted of a third-degree felony, you have to wait 3 years. For first degree, or for fourth and fifth degree felonies, I believe it's 1 year. And so, you currently are not eligible because this will be your 2-year anniversary in December from your discharge. So, and my, if you have anything that I'm looking at wrong, Mr. King, let me know. But that's why you read it, that it's a 3-year.
You're correct, yes, under 295332A1A. You're
right.
Correct.
Mm-hmm. Yeah. And so, based on that, I have to turn you down, but you can refile on or after December 16 of 23 next year. And then at that point, I don't see any reason why it won't be granted, because you have no other felony convictions, and everything else is just traffic tickets. Well, there was a check case 20-some years ago in Washington Courthouse, but that doesn't really matter any. So as long as you keep your what you're doing, you staying out of trouble and leading a law-abiding life, you can refile in a year, a little over a year, and we'll be able to grant it pretty quickly. All right. Okay. Sorry about that, but
all right.
That's one of the things they're trying to make it a lot easier for people. And there's actually, again, there's been another proposal, as I understand it, to make some additional changes. So you might watch the news. They may change that. Right now, for felony 3s, which is the highest degree that's available to be expunged or sealed, it's a 3-year waiting period. And then for 4s and 5s, it's 1 year. So, okay? All right. Thank you. They'll be denied without prejudice refiling.
the record in the matter of Parsons versus Parsons. Case number 08-DR028. Case before the court is a hearing on a motion for contempt. Court notes for the record that Mr. Parsons is present via video from the Highland County Jail. Mr. Rader is also present before the court. Heather Parsons has not appeared. Mr. Rader, anything to report in this case?
Yes. Mr. Parsons, can you hear me okay?
Yes, sir.
All right. Your Honor, I did speak with Mr. Parsons. He has a case downstairs as well. He admitted to a contempt down there. Did indicate to him that this was a fourth contempt. He indicated it would be a 90-day jail sentence that would be suspended on the condition that he paid $1,200 for a purge hearing. Asked that to be set out 90 days. He indicated he would be admitting to the contempt, would ask that he be released from jail, and the agency would agree to vacate the driver's license suspension.
So, Mr. Parsons, you are here today without an attorney, is that correct?
Yes, ma'am.
And do you wish to apply for court-appointed counsel?
No, ma'am.
You understand that if you did qualify, the court could appoint an attorney for you?
I understand, ma'am.
And Mr. Rader has indicated that you're willing to admit to the contempt, is that correct?
Yes, ma'am.
So you admit that you have failed to pay child support pursuant to this court's prior orders?
Yes, ma'am.
And can you tell the court why you've not been able to pay your support?
I was paying up until about March of 2020 when the pandemic had came on and my license, my ID got expired, and I wasn't able to renew it at the time because the all this court stuff had come above. So it's you know, but Judge Greer, he lifted everything Tuesday so I could get my ID and get back to work.
And so, do you have a job waiting on you that you can go back to?
Yes, I do. I could either go back to working at Royal King Distribution or the gas station walking distance where I live at is hired. They done told me they would hire me if I could get an ID.
And so, your agreement with Mr. Rader is that you would pay $1,200 in 90 days. How are you going to come up with that money?
Go back to work.
Okay. And do you also have a child support contempt pending in the juvenile court? Is that what I heard you say?
I believe so. It was over my daughter that she's not even residing in this county anymore. She lives in Gallup, Pleas, so okay. All that, I believe, was transferred down there.
So at this time, you don't have a lump sum that you're trying to pay downstairs as well? That's
yes, he does.
Yes, yes. $250.
Is that correct, Mr. Rader?
Yes.
So $250. So you're going to have $1,200 here and $250 downstairs that you have to come up with?
Yes, ma'am.
And do you admit that this is your fourth offense, child support contempt?
Yes, ma'am, I do.
So I've been on the bench here since 1997, and I can count on both hands the number of people that have had more than 5 child support contempts. So you're getting up there with me. So I don't want to see you back here for your 5th. Do you understand that? Because
yes,
if
ma'am,
you come back before me on a 5th offense child support contempt, it's highly unlikely that I'm going to follow the recommendations of Mr. Rader. Do you understand
yes,
that?
Ma'am. Yes, ma'am.
So, Mr. Rader, how much is his total arrearage roughly?
Approximate balance of $35,167.83.
So roughly $35,000 arrearage that you owe here. So if you come back in front of me for a 5th offense contempt, there's a chance I'm going to tell you you have to pay that arrearage off before I purge any jail time. So you come back here again on this, you're probably looking at 90 days in jail because I'm going to make your purge so high that you can't get out. You understand that?
Yes, ma'am, I do.
So, Mr. Parsons, I'm going to accept this 4th offense contempt. I am going to order 90 days in jail, which I will suspend, and give you one-time chance here to pay this $1,200. You have to pay it by January the 4th. If you fail to pay that by January the 4th, I want you here on January the 5th at 2 o'clock. You understand that? If you
Yes,
fail to
ma'am.
appear on January 5th at 2 o'clock and you haven't paid that, I'm going to issue a warrant for your arrest. And again, I'll probably hold you until the hearing.
Okay.
In addition to that, I want you to pay the court cost of this action. I don't know what they
Okay.
are. They'll be available online after this hearing at the Highland County Common Pleas Court website, or you can get it from the clerk of court's office, how much those court costs are. But if you pay your $1,200 lump sum and you haven't paid the court cost by January the 4th, you still would have to appear here on January the 5th. So, even if you pay that purge amount, I want you here on the 5th if you have not paid your court costs. Do you understand that?
Yes, ma'am.
And I'm going to put all this in writing to you and get a copy of it to you. But I just want to make sure that you're aware that you have to pay both the lump sum and the court cost, or I need you to be here, or I would issue a warrant. In addition to
ma'am.
that, I will release your driver's license suspension subject to any reinstatement fee, so long as the child support suspension is the only suspension that you have.
Okay.
Mr. Parsons, do you have any questions about any of that?
No, ma'am.
Mr. Rader, anything further in this case?
No, Your Honor, thank you.
So if there's nothing further, Mr. Parsons, I'm assuming that let me make sure I have a correct address for you. When you're released, where are you going to be?
11190 US Highway 23, Lot 152, Waverly, Ohio, 45690.
So, Mr. Parsons, I'm going to do an entry that will immediately allow you to be released so long as I have the only reason that you're incarcerated. Okay?
Yes, ma'am.
Anything further for today?
No, ma'am.
So, Mr. Parsons, one other recommendation. The next time you come before me, I would suggest you tell me that you have transportation to and from court and make sure that you get back and forth to court.
Yes, ma'am.
Otherwise, you would have been out before now.
Okay.
Anything further? Nope, we're adjourned.